Good morning. Good morning. Good morning. It's Thursday. It's July 20. What day is it? 24th, 2025. I wasn't sure if we would still be in the sentencing hearing from Brian Kohberger today. And I wanted to give space if we were still in the sentencing hearing from Brian Kohberger today. I'm not going to talk too much about Brian Kohberger's case today, just because, well, yesterday was hard and it needs a little distance. So replay crew, for all of you just tuning in, love you. Everything will be timestamped down below. We're just covering one topic today. I don't have bandwidth for much else, honestly. Yesterday was tough. And today we're going to lean in to something that I think will just cause rage. And everybody's like, I'm ready to feel something other than the deep pits of grief and sadness. So law nerds have been like, Emily, you'll be mad. Let's all be mad together. Because what we are covering today is Adam Lally, the prosecutor from the Karen Read first trial. And he questioned a couple of witnesses in another trial or in the second trial. And he is testifying in a discovery hearing in an unrelated homicide case. So this is not related to Karen Read in any way, other than it's incredibly rare that prosecutors take the stand and testify. I keep saying these things don't happen. These things keep happening. These things don't happen. These things keep happening. This thing will not happen. Emily, have you been watching Santa Clara Vanguard's 1989 Phantom of the Opera show? Yes, because I needed to tell Travis that there was in fact a Phantom of the Opera show and there were masks involved. But this doesn't happen. So I saw that other individuals, Laura, and I'm sure there are others that I saw were covering it and have blanked on. And I was like, you've got to be kidding me. So for those of you who are like, Emily, we need to know what a prosecutor is going to say, we are going to cover it today. The reason I was like, it's not related is because this case is not related to that case. However, the behavior in the Karen Read case was mind-boggling. And I was like, what? And so this, I think, will give us some of an insight, because once I realized there was a hearing, I kind of looked at the topics and went, okay, I'm going to watch it live with the law nerds. Because, again, discovery shouldn't be this much of an issue. Here's how discovery should go. From my perspective, hey, defense attorney, here's everything that was initially turned over to me. Let me back up. When things are initially turned over to you, you make a note of everything that was turned over. Let me back up further. Jordan, back it up. Let me back it up a little bit further. Oh, my in-ears are just like, what are we doing? Let me back it up a little bit further. When law enforcement turns something over, you should often get a receipt, email, something that memorializes what has been turned over. All reports, number through number. All this through this. CD, thumb drive, whatever. If you're not dealing with digital discovery, if you're dealing with paper discovery where they're handing you papers. And then if they're handing you digital discovery, there should still be a note of, hey, we put all this in the drive. Why? So you can go check it and make sure it's all there. Make sure there's no pages missing. And then when you get those as a prosecutor, you look through them to make sure there's nothing obvious missing, even if you hadn't had a chance to read them all yet. And then, I don't know how other people do this. I don't know how else you would do this. And then you look at all of that and you go, okay, it looks like everything's here. It looks like all the pages are here. There's nothing obvious missing. It's not like autopsy report and you look through and you're like, there's no autopsy report. So you make sure there's nothing obvious missing. And then you make a list, or you take the same list and then you give it to the defense attorney with the papers and the list. And then I used to have the defense attorney sign it. Sign the list that I'm giving you this. I've checked it, and double check it. Double check that it looks like you have everything. And then they would double check it and then they would sign it. And then I would have like a signed receipt and they would have a list of what I gave them with the date I gave it to them, where we were. Like, I handed this to you in court, we were on this hearing, or you came to the office and picked it up or whatever. And then I knew. And then I made a note in my file that said, on this date I gave this thing, and I would hole punch the thing. And I said hole punch this way because normally our files had like 2 prongs on each side. I would hole punch the thing and then put it in a file. And then you just keep doing that if there's more discovery. And then if the defense is like, hey, report 5 references report 3. I don't see report 3. And I'd be like, I don't see report 3 either. Yo, we don't have report 3. I'm gonna need that. And then I would make a note that I asked for it. Why? Because I would forget. I was at times dealing with, 15 at a minimum cases when I was dealing with heavy cases. And then on the day-to-day of cases, substantially more than that, I would forget. So I needed to keep track of everything in the cases. And then there was a substantial period of time at the DA's office when I was also having health issues. So there were times when I knew that if I was missing a court day because I was having back surgery again or whatever, that if somebody else picked up my case, I wanted them to know where we were and know what needed to be done. Because there was no way if something happened, I could go through all my files and make notes and try to catch up on everything. That was never going to happen. Did this always happen perfectly? No, it didn't always happen perfectly. But there was always a note somewhere, even if it wasn't a pretty printed out receipt. There was always something written somewhere. Did I receive cases with no notes? Yep, occasionally. But then generally the officers would have notes. There were times I got cases from other DAs and I would call the investigator and be like, there are no notes in this file. Can you please tell me what has happened? And the investigator would be like, these are the things we've turned over. And if you want to turn it over again, turn it over again. And oftentimes I just would. I would be like, okay, give me all the discovery again. We're turning it over again. So the defense has it. They have to have the case file. It's literally like a massive part of your job. Emily, lawyering sounds like a lot of paperwork. Yeah, it's a lot of paperwork. It's like the main part of your job. The defense has to have it. So I know that there are discovery issues in this case that we are going to watch. This is a separate murder case. And the reason I say it's separate from Karen Read is the actual criminal case is not connected. But the patterns of behavior are, because we saw massive discovery issues in the Karen Read case. And I'm like, how the fuck does this happen? And I have a feeling the fact that a DA is on the stand testifying before a judge means that there is enough how the fuck does this happen going on in another case in Norfolk County, that the DA is on the stand under oath having to explain themselves. That doesn't happen because we never get to that level of what the fuck that the judge is like, get under oath and tell me what the fuck happened. That never happens. And we've seen it in 2 cases and we don't cover that many cases. It's unbelievable. So we're going to cover it today because I don't even know. On other notes, the Moscow Police Department has started releasing police reports onto their website. I'm not going to talk about that a lot today. I have not had the bandwidth to start going through those yet. I am sure there are going to be headlines everywhere. Look, those headlines aren't going to change. Those documents aren't going to go away. If you need a little space from the details of that case, please take it. It's okay. The information will be there. But when I started looking at it, the first thing I noticed was the very first page had an evidence log, the very first document. So I might pull up the document that's just the evidence log to show you what that looks like. For those of you that are like, Emily, you keep yelling about why is this not logged? It's a great example of what that should look like. So we'll pull that up because oftentimes when we cover cases, we don't have the case file. So it's not often that I get to pull up documents and show them to you because we normally just have all the filings in court. And I'm not pulling up case files because I don't have case files in my office from criminal cases. I don't do that anymore. So I know what they look like. But I will give you an example of what that looks like. We're not going to go through any of the details on that. I just wanted to let you know we're not going through the details on that. But I will give you an overview of what some of these things look like as we get to the end of the hearing. So you can see what I thought was normal practice. Because, I don't know, I worked in an office with hundreds and hundreds of attorneys and was like, this is normal. Apparently it's not. So we're gonna swoop a doop. We're gonna go to court. This hearing was from Monday this week. It was a Kohberger week, and then Emily has got to stay on time because I have to travel to go see T, and then go out to dinner with Dr. B, even though we are traveling because we have not had time this week to celebrate our wedding anniversary. So we've got travels. We've got travels. We're gonna be like cheersing Starbucks in the Atlanta airport going, happy anniversary. So we haven't even had time to celebrate our anniversary. So there we are. 23 years of marriage. Which is why we're just like, we'll get to it. We want to go see Travis. That's what we want to go do. We want to see all the DCI groups perform. But honestly, the number one thing I want to do is see my kiddo. So we're going to 2 shows. So our first show is going to really be watching Cavaliers perform and then going to the lot and seeing our kid. Second show, we're going to watch some of the other groups perform. So it's going to be great. So AR, I saw that the Hattiesburg show, I think most of the groups didn't end up performing because of the heat yesterday. I think a lot of the shows didn't perform. It was a bummer. Nikki, they will be at Lucas Oil. They're not at Lucas Oil just yet. All right, let's roll the intro. And let's go to court with Attorney Lally. What, if anything, did Lally do this time? That's the question. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I'm going to have to change the intro at some point because I think when all the law nerds were like, girl, you have to cover this, I think today you were here for the fuckery. Like, I think today you were just like, Emily, we need you to tell us the facts because what we have observed is fuckery and we cannot observe the fuckery alone. You must observe the fuckery with us. Emily, get into the fuckery with us, girl. We want to talk about it. So today, the law nerds are like, today, we are here to observe the fuckery. So today we are not causing the fuckery. We are discussing the fuckery. We're going to try to bring some facts. So all of you who are using the words, I am sorry, only half of those comments will go through because Google will swoop a lot of them, but I see you. So let's go to court. Different judge. Looks like maybe the same courtroom. And Attorney Lally at this freaking discovery hearing. Okay. Law nerds, let's go. Let me know where you're coming in from. I didn't even ask. Let me know where you're coming in from, what you're drinking this morning. Are you hydrating? Are you caffeinating? Are you elsewhere in the world? Are you libating? What are we doing while we watch this together? Let's go.
Certain materials bait stamped in the Notice of Discovery 28. It's a little difficult for me to figure out.
By the way, the bait stamping is incredibly helpful in like homicide cases. It's not done in every case. I would never say it needs to be done in every case, but it takes every single piece of paper and just gives it a number in order. So even if it's like police report 1, 5 pages, it will number those 1 through 5. And then the next report will get additional numbers starting at 6. So they stay in order.
Whether this is entirely new based on the chart or whether it's some
yes, that's Adam Lally's forehead.
Similar document or similar information, but in a different form or
just so I don't forget,
what have you.
If there's things I want to
take any line, you know, I mean, take Bates number 114 towards the bottom of page 13. Mm-hmm. I guess it's item 114, Bates number 228 to 232. Milton Police Department incident report is the way it's identified.
Right.
And there's an indication here provided to Attorney John Geary.
Correct.
So it looks to me like you're saying that this document, although recently produced by ADA Hickman, was previously produced by ADA Lally.
To the prior counsel.
To prior counsel, and presumably to this counsel also, because I'm sure all the documents were, all the discovery was
So at this hearing, Lally's represented by an attorney, and they are talking about the new DA that has taken over the case and who it was turned over to.
produced when new counsel came in. So I don't know if there's a dispute about whether item 114 in discovery packet 28
Not docket 214.
is or isn't different.
Correct.
That's what I'm trying to get my arms around.
I understand that, Judge, and we've gone through those, and we've pulled them, and we've pulled out the original that we got in 2021, if there actually was an original, and then we'll put it together with what we got in 2025. So we've done that for a number of items in that chart. I think maybe all of the items in the chart, except for the videos. We haven't compared the videos because we'd be here till next year trying to compare the
Well,
videos.
some of the videos are video clips that were produced originally,
Yeah,
and they've given you the whole video. And I guess I don't know if
They are
that
talking
matters.
about what was turned over
You know,
and what
obviously
wasn't.
you now have the whole video. It would have been good if the whole video was produced, but oftentimes there's all 12 seconds in a video that matters, and you know, it's hard to know whether the omission of the entire video matters.
Understood, Judge.
I think what's hard for prosecutors, just talking about videos, is that there's times if there are 45 seconds of a video that's like the relevant part, but you dumped 10 hours of video and you turn over the 10 hours of video, the defense will be like, they're burying us in discovery. They didn't give us the relevant part. But then if you turn over just that part, they're like, but isn't there more video? So sometimes those things just become a catch-22. This is why your reputation matters in the profession of law. Because if you have a good relationship with the defense attorneys, you can tell them, would you like me to turn over all 10 hours of video? Or would you like me to give you the clip where the thing happens? Or would you like me to tell you the timestamp of where the thing happens? And then I will do whichever one you prefer. If you don't have a good relationship with defense attorneys or other attorneys, then it makes it a lot harder. Working well with opposing counsel matters. And I think this can get a little stickier for defense attorneys because if their client oftentimes sees them working collaboratively with the prosecution, there are some clients that thinks like the fix is in. They're like, they're working with the prosecutor. They're all against me. Oftentimes, when everyone can work together, cases get resolved better. So you should be able to work those things out.
So, you know, if I were to go through the first 6 items here on page 13, for example, of Mr. McKee's memo.
Sorry, Chad, I forgot to turn on closed
How do I figure out whether it is or isn't different? I mean, do you also have a spreadsheet that would sort of match up here and describe what's different or what's not? Are you just...
So the court is saying, how do I find what was turned over to the previous defense, I think defense attorney, what's been turned over now, what you have, what you don't have? How do I figure out what's been turned over, what hasn't? The judge is like, I need help.
Doing sort of...
document.
Okay.
We were going to ask witnesses, but now I understand the court doesn't want us to do that. I'm
No,
happy to.
you could. Okay, you could, but we'll be here until the cows come home.
Or the horses come to practice. Robin asked about the attorney of Lally testifying. We don't have Lally testifying yet. We're starting at the beginning of the hearing for context. So
I don't know when the last time there were cows in Dedham. But you know, bottom line is there probably is an easy way to figure out or to sit down and coordinate what isn't new and what's not, and then figure out whether it matters.
And to this point about, and you mentioned the word matters.
Well, that's prejudice.
Yeah.
Okay, that's whether there's prejudice.
All of the cases cited by both counsel, myself and Attorney Scaficcio, talk about individual documents that were provided midstream in a trial or right before trial or after trial. there hasn't been an articulation of what of any of these documents prejudices the defendant. And I just can't, I've attempted to provide Your Honor with some kind of macro areas that were new and explain them, but I don't know, I can't respond to what I don't know. I don't know which of the documents that were newly provided prejudice the defendant such that the public doesn't have a view a public trial. And that grave.
So what the attorney is saying is, hey, what of the new things that the defense is saying weren't turned over would prejudice the case enough that the case should get dismissed? That's essentially what the argument is. They're saying the defense needs to point out what the problem is to deal with whether or not there's a Brady violation. That's where they're going with that. We don't have all the documents beforehand. This is a different case. This is from a separate homicide case, but that's the context of the motion, which is why we saw Carrie Morrissey on the stand in the Baldwin case. It was whether or not there was a Brady violation that required the case to get kicked out. So because this is a Lally case and he's the one that's going to testify, we are covering it. I am not covering the underlying case, if that helps. Let's continue.
An extreme remedy. Since this motion's been filed, the Commonwealth and the defense jointly requested that the defendant's bail be reduced to $2,500. Judge set it at $10,000. He's posted it. The trial is off the list. What I'm trying to understand, and I'd ask the court to order it, is if we're going to meet about, I would like to know which of these documents in a pleading prejudices the defendant, so I can respond to it. I have police here to explain some of these macro issues, but I did that almost as anticipatory and trying to help the court, but I don't know even what they're asking or suggesting is prejudicial to the defendant and would prevent him from having a fair trial.
Okay.
Remember when we covered this in the Reed case and others, when you have the Brady violation, you also need to look at what the remedies are and whether the remedy is, I don't care if you're ready for trial, it gets delayed and you turn this over, or if the remedy is the case getting dismissed. There's a spectrum of remedies from less severe to more severe.
Judge, I think you're right. There are two issues here. There's their failure to produce Rule 14 discovery, which could result in sanctions other than dismissal. And I think that's an easier question.
Keep listening, Emily.
Because that's all the notices of discovery that ADA Hickman put together, where she noted specifically, this was not provided before, this was provided before. That's easy for the Commonwealth. It's their document. They gave it to me. So they shouldn't be confused by what they gave me and they identified as new. If they're now saying some of the stuff that ADA Hickman said was new isn't new, then they got to tell me about that, because that's what they had represented and that's what ADA Hickman had represented when she took over. So to the extent that we all need to sit down, I'm happy to do that, Judge, but there's two different lines of questioning here. One is, where's the stuff been since 2021? Because my client was in custody for almost 4 years, awaiting trial, and we had a September trial date. And then, where's the prejudice? So they're jumping all the way to the prejudice, and we still don't have our arms around where's it been since 2021.
Right.
That's the defense attorney saying, we were supposed to have trial in September. This case has been pending since 2021. WTF? Where is it? Where has it been?
So before I deal with the prejudice issue,
It's not just
it
me.
seems to me that I ought to know what is new and what you think is materially new. Okay? And I know that puts a burden on everybody to work together, but it seems to me that we ought to do that. I have two other matters on this morning, so we're gonna break by 11:30 today. Okay, I think I can begin by taking evidence on the question of where has this stuff been and why wasn't it turned over earlier? And,
which is what we're here for.
We're going to have to adjourn. We're not going to finish this today. And in the interim, I can have you folks get together and do a comparison to figure
That's
out
reasonable.
this is new because it has somebody's handwritten notation in the upper right-hand corner. This is new because it's the full unredacted video, and the redacted video of 12 seconds is the only relevant portion, or whatever, okay? And we can get our arms around materiality, we can get our arms around prejudice, and maybe it will also focus some of the attention on why wasn't this turned over? Because it may be that this is all stuff that was annotations in one person's file. I don't know. You know, I'm not saying that's the situation, but it'll focus us a little bit. But it seems to me we can use the morning
Solid plan, Your Honor.
by
Let's
beginning
go.
on the first question, which is why wasn't this turned over in a timely manner?
That's a great question.
How do you want to proceed on that?
We should start with why the fuck wasn't this turned over in a timely manner if this case has been pending since 2021 and we are in 2025 and trial was set for September 2025 and shit's still not turned over. That's crazy.
Score.
I would then call ADA Lally first because he was the first one to touch the file, Judge.
It's the defense attorney.
It's the defendant's burden. Certainly it's our motion, counsel's motion. I do also have here, just for I have 2 Milton police officers and state police, Lieutenant Tully, that I would offer the court to explain the Milton aspect and the items that ADA Hickman produced after going to the Milton Police Department and copying paper files and receiving an electronic file from them.
Okay.
If you are having trouble with law enforcement giving you information or they don't know what information you need, you take your file and you go to the police department and you sit your butt at a table with your officers and say, show me everything that you have. And we're going to go page by page and make sure nothing's missing. If you haven't had the case since the beginning, sometimes you get a case at the very beginning stages. Sometimes you get a case before it's filed, depending on what type of casework you're doing. But if you get a case midway through, you have to double check it because ultimately it's your bar license. Even if law enforcement's like, this again. Yeah, this again. My ass isn't going down because you didn't turn something over to me. Fuck that. I'm not getting in trouble for your shit. No way. That shit's pissed me off since I was like 6. I didn't do that. You did that. I'm not going down. You just go and sit down and do it. It doesn't seem like that's wild. You just have to double check. Most of the times you have everything and it's fine. But it's the one time you don't have a thing that's a problem. So when they're saying, that I assume it's the other DA went to Milton and looked at the paper file. Yeah, when you take over a new case, that's ideal. If it is a case with 3 police reports, it's probably not a problem. If it is a homicide case, you always double check. Yeah. Not hard. And then you get like a field trip on your work day. It's like, I'm not going to be in the office. I'm going to the department. And then lunch.
Take care of a bulk of what ADA Hickman provided in the spring of this year.
Why don't we start with ADA Lally?
Sure.
Okay. And it may.
I saw Dawn said, Emily, you're too honest for this state. Look, I am a consummate rule follower. The only time I chafe at that a little bit, if the rules are arbitrary and dumb. I don't find in law the rules are arbitrary and dumb. They're meaningful and they're necessary. And I agreed to them when I signed up to be a prosecutor. You don't have to be a prosecutor. It's actually not an easy job. Well, it's not an easy job to get where I was working. You choose that job and you choose the burden that comes with it. And you're like, I know I can do this well. But also, I don't like getting in trouble. Like, I don't want a judge to yell at me about shit. I don't want to get in trouble, especially for shit that's not my fault. No way. I don't need some appellate court being like, this DA, which has never happened to me. I don't need some appellate court being like, this DA didn't turn this over. Never. Fuck that shit. No. Especially when it can all be rectified by asking a couple questions. Also, if you have a good working relationship, it's pretty easy to sit down with your law enforcement officers and be like, can we just go through this and make sure? And I would often say, I am very ADHD. I am hyper worried that I have missed something. I have a lifetime of elementary school trauma over like, I will forget to do my homework. So we are dealing with like deep rooted anxiety. So I just need to double check so that I feel better. And so that I can tell the defense attorneys who I have a good working relationship with that I have done my job. And so that if we go to trial and there's a conviction, I know that everything was turned over and this case was done right. I am a rule follower. I do not want to be in trouble. Also, if I can't prove a case, I'm not going to bring the case. Even when I looked at a case, and this happened more often than not, when I looked at a case and I went, I know that this person did that thing. I also know that I do not have enough evidence to prove it. So this case is not getting filed, and that sucks. But you can't go to trial on vibes. That's not how it works. Okay, let's continue. We're never going to get through this. And then Dr. B is going to be like, girl. Planes don't wait for EDB. I mean, at this point in my life. Maybe one day. I'm teasing.
Maybe that you also want the talk to the Milton people.
I'd ask that everybody, all the witnesses be sequestered, Judge.
That makes sense.
That's fine.
Okay.
They've been here all morning.
And
May I approach on behalf of ADA Lally?
sure.
Briefly. Judge,
This is whoever's representing ADA Lally. They said their name, but this is whoever's representing ADA Lally.
Attorney Pat Hanley on behalf of ADA Lally, who's...
Oh, you're near a microphone. You're good. Okay. Go ahead. Give me your name.
I like this, Judge.
Patrick Hanley on behalf of ADA Lally.
Okay.
Patrick Hanley.
I had filed, I think, either Thursday or Friday and served upon the Commonwealth and Attorney Scapiccio a motion to limit or perhaps modify the format of any presentation by ADA Lally. ADA Lally is an officer of the court. ADA Lally.
The trial channel, thank you. It is so helpful. It is much appreciated that you caught this. The law nerds had asked for this video over and over and over again, so thank you. It is fantastic, and it is much appreciated.
I anticipate is in a position to answer many of the questions that you have or that are raised by defense counsel, but that he should do so from counsel table and address them directly rather than in response to questions. I'd suggest that it will be faster. He's prepared to do it. And if there is there's follow-up questions that the court has or that are derivative from defense counsel's motion, I suspect that he'll be in a position to answer them. And so I'd suggest that be the format.
Lally's attorney's like, he should sit at counsel table and we should just have a chat. This isn't a chat, sir. If we're at the point where somebody has to be under oath to take evidence in a Brady hearing, you're getting on the stand. And this isn't even like the case with Carrie Morrissey, where Carrie Morrissey's like, no, I'm putting myself on the stand. Carrie Morrissey's like marching to the stand, and the defense attorney's like, you don't have to do that. That's not the case here. The case here is Attorney Lally's attorney saying he's not getting on the stand, and the defense is like, go sit on the stand. I'm asking the question. I'm in charge now, Phasma.
Why? And because it will be faster. It also obviates the need to examine defense counsel to the extent there's any question of what was sent to defense counsel before or what was raised in documents before. Defense counsel, I would suggest, shouldn't be on the witness stand, and he shouldn't be on the witness stand. The last thing I would say is if the court is inclined to put him on the witness stand, I'd ask for the opportunity to, at the conclusion of defense and Commonwealth's questioning, to question him and raise anything that has not been raised in his testimony by that point.
The motion is denied. Mr. Lally can testify like any other witness. He has relevant testimony. He's being called as a witness, and he can testify as any other witness.
You're You're just like us, you big nobody. Sorry. The movie quotes are happening today. I don't know. We switched from music to movies overnight, apparently. But no, Attorney Lally can testify just like anyone else. The judge is like, no, get your ass on the witness stand. You're not special. You have relevant testimony. It doesn't matter. Go sit down.
Lawyers do it all the time. ADAs do it all the time.
I mean, not like
defense
this,
attorneys from time to time do it.
Sure.
Okay, and so we can proceed.
May I, well, I'll say this. The Commonwealth has filed motions to quash,
It's one of my favorite twos, Amy.
and one of them partially with ADA Lally. And this goes back to my initial point about narrowing the scope here and focused on the discovery issues at hand. And ADA Lally is subject to a protective order on another matter. And I would ask the court to...
What? ADA Lally is subject to a protective order on another matter? Y'all, if we start digging into the rabbit warren that seems to be Massachusetts, or at least Norfolk County, we are going to end up in Australia. Like, we are going to end up on the other side of the world if we start digging. I'm just making an asterisk. We're not getting into it. This is an asterisk for, I want to know what this means. I will look it up and we'll find it. What the hell? Priya said, EDB, is it safe to say this is your first view? Yes. I saw that people were covering it. I saw that it was a discovery hearing, and then I stopped because I want to cover it with y'all.
Review the Commonwealth's motion to quash, and if we are taking a break here,
I will look
and prevent.
I will look up I will try to find more about the protective order. So I'm not going to speculate. I'm making a note for me to look at that when we have a chance to look at that. I have a feeling that EDB Air is going to need a direct flight to Massachusetts. We're going to need our own lounge in Logan.
Preclude counsel from inquiring about those issues that he cannot testify to and will not testify.
If there's a protective order issue, we'll address it. Okay, and if he feels like he can't answer a question because he's subject to a protective order in another matter, we'll deal with it.
Thank you.
Okay.
And the other part of this is these were, and I'll just pass them up to Your Honor. These were the subpoenas that both ADA Hickman and ADA Lally received from counsel seeking production. It probably dovetails with counsel's request for all the emails. I would ask that the court quash in so much as the request for the file and any work product and anything that goes beyond Rule 14, mandatory discovery, anything that involves work product, mental impressions, or anything of such should not be part of this questioning.
So right now, part of this questioning is, what did this ADA know?
Right.
What did he do?
Thank you.
Okay, who did he talk to?
What, if anything?
That's arguably work product. It gets discovered in this context,
Right.
because the question is,
If you do your work product doesn't get discovered. But if your work product is a note saying, I told law enforcement that I needed this piece of discovery report or whatever by this date, and they responded, I don't have it, that doesn't exist, those notes are technically work product, but they're very relevant here. I like this, Judge.
why wasn't this stuff produced in 2021? I understand that could be embarrassing for the office. I understand that could be embarrassing for certain individuals. That's where we are right now.
I am not a big fan of shame, but if it's you are not doing your job while somebody is sitting in jail waiting for you to do your job, you should be embarrassed. You chose this job. No one volunteered you. You chose this job. You don't have to, there's a fuck ton of lawyer jobs to choose. You don't have to choose this one. So yeah, am I harder on prosecutors? You chose this.
Right now, in this particular case, because lots of stuff from 2021 wasn't turned over. Okay. So it may be that emails become relevant to this testimony, okay? Who knew what when, and what did they do or didn't do in order to follow up? So I'm going to have to deal with this on a question-by-question basis. I cannot quash it across the board.
And he
Right.
shouldn't.
And I would agree, Your Honor. I actually, to that point, I have included emails to explain the issues at hand. So this is not, when I can understand an issue, I provided the emails to help explain it.
Okay. All right.
Thank you.
ADA Lally, you're on.
Yes. Mr. Lally, if you could come forward to be sworn.
I apologize. We have witnesses here. You want them?
Yes, sequestered, yes.
So counsel's also, we have a motion to quash this subpoena entirely. ADA Hickman, do we want ADA Hickman present for this questioning?
I do not, Judge. She's going to be a witness as to what how the condition of the file as she found
Yeah,
it.
they should all be
So she
sequestered.
Listen to what Lally says he had in the file before she testified. That's no dispersion on ADA Hickman at all, Judge.
I understand. I'm going to overrule the request for sequestration of ADA Hickman. She's counsel of record now and an officer of the court, and I'm confident that we do not need to extend the sequestration order to her. Your objection's preserved, Attorney Costa, to the extent you join in the objection.
I'm joining the objection, Your Honor.
And you can.
I think it is helpful to note that there were many who took issue with the way that that Judge Cannoni said certain things. This is one of them. But this judge is also saying, and I say sometimes these are regional specific things, this judge is also saying your objection is preserved. Like it's noted, it's preserved for the record. That language might just be common to the bench in this area or in Massachusetts. So I just want to point out that this judge is also saying that's preserved. The ADA that's currently on the case, from what I am gathering, is Hickman. They are allowed to stay in the room, even though they may also be a witness to this discovery hearing. And ADA Lally is going to take the stand to testify why between 2021 and now, discovery wasn't turned over. We're going to find out what that discovery is as we go through the hearing. The sequestration order means that other witnesses can't hear what's being testified to. So they have to go back outside of the courtroom. So they are sequestered away from hearing what the witnesses testify to.
You have a standing joining of objections, if you wish, all defense counsel.
Thank you.
Okay, but others should be sequestered.
The witnesses are.
Oh, hello, Jim.
Thank you.
So law enforcement's not in the courtroom. ADA Lally is being sworn in to testify. That's the point. But I wanted to see the background of this, not just jump into what Lally was saying.
The truth, the whole truth, and nothing but the truth, so help you God. Thank you.
And that sounds like Adam Lally.
Good morning, Mr. Lally. In a loud, clear voice.
Hopefully the camera switches. We'll see. A number of you are asking, why did ADA Lally take this case over? I have no idea. It happens in prosecutor's office that other DAs take over cases. It might have been that when the Karen Reed case happened, ADA Lally was busy handling that case and other cases got shifted. It's not uncommon that cases get shifted around. To me, that's not a weird thing. That's a normal thing.
Could you please state your name, spelling your first and last name for the record?
Sure. Adam Lally, ADAM, last name Lally.
And what do you do for a living, Mr. Lally?
Assistant District Attorney with the Norfolk County District Attorney's Office
And how long have you worked for the Norfolk County District Attorney's Office?
since 2005.
20 years?
Yes, almost.
What did you do before?
So attorney, assistant DA in Los Angeles, they were DDAs, but ADAs, ADA Adam Lally became a DA essentially the same time I did. That's an interesting perspective for me. I've been a lawyer 25 years this year. No, 20 years this year, because 2005. It's 2025. Fuck, that makes me feel old. Wow. Okay. Same.
Before you worked for the Norfolk County District Attorney's Office?
Started with the district attorney's office straight out of law school. Worked a couple warehouse jobs, things like that during.
Sorry,
I worked a few warehouse jobs, things like that during law school. Went to school at night.
okay. And what school did you go to?
Suffolk.
Suffolk Law?
Yes.
And undergrad?
Undergrad, I went to the University of Southern California.
Okay. And
What? Adam Lally's a USC guy? Well, go Bruins. That's the whole that's the whole problem. That's the whole problem. Is Lally from Cali? Hey, Lally. What? I have so many fucking questions. How did you go from University of Southern California? Well, I mean, I grew up near University of Southern California and went to UMass. So, I mean, same girl, same. Do you want to know why I went to UMass Amherst? Do you want the cold, hard truth, the reality of the situation? The reason I went to UMass, I very much liked UMass. I very much liked my water polo coach. I liked the University of Massachusetts very much. But here is the reality. University of Massachusetts had a new Division I women's water polo team. USC, UCLA, and others had very well-established women's water polo teams. All of my water polo statistics will not say this. I am 5'6". They will all say I am 5'7" or a little bit more. I am 5'6". I have very short T-Rex arms, and I am not the fastest girl in the group. So was I playing water polo at USC or UCLA? No, I was not good enough. UMass Amherst, though we were Division I, was a growing program. I was willing to join a growing program. Was I going to play water polo at USC, where everyone had a 6'4" wingspan? No. I wasn't even tall enough to have the coach look in my direction. I mean, and if he did, I would have been like, don't take bribes. Emily, now you're just being fucking shady. That's fair, I am. I'm just being fucking shady. So I went to the program that I could play water polo in because it was a new program. You see, I was not good enough to play on the West Coast. I was just not. It is just the truth. I am not tall enough. I am not good enough. My brother, yes. Me, no. So UMass had a lot of opportunities for me that I was excited about. Also, some of us may have this feeling. When you grow up in an area for your entire life, and those you grow up with, I have great and lovely friends. But there were a substantial amount of people I grew up with that just made my life a living hell. So anyone who has had that experience growing up where people are just cruel, I had that experience too. And I was really tired of being bullied. So I went to the other side of the fucking country to go to college with no one I grew up with. Like none. And the high school drama that was happening at UMass Amherst, because so many people locally went to school there, the high school drama was still playing out. Nobody knew who the fuck I was. It was glorious. I needed to run, like the fight or flight was so high. I needed to run the fuck away. And as a bonus, I got to play water polo at all of my 5'6" stature. But I was not good enough to play on the West Coast. I have questions about why Adam Lally ended up at USC, how he ended up going to night school, law school, why he didn't just go to USC law or UCLA law. And I am not going to shame anyone's law school because, as we know, grades are not everything and skilled lawyers can come from anywhere. Camille Vasquez and I went to the same law school. There are people who went to USC law that would just absolutely shit on our law school, which is dumb of them because we'll kick their ass in court. But I have so many questions. I have so many questions. Damn, I'm so curious. So for those of you being like, which USC? USC Trojans, not USC Cox. West Coast USC. I have so many questions. Different USC. PK, Murdaugh's son went to USC Cox, not USC Trojans. But I just have so many questions. Okay. I'm going to make a note. I'm going to come back to this later. We have to just go. We have to just go. Or I am going to continue to buffer. University of Southern California, really? Huh. Interesting. This is true. Jolene, this is true. We did all pass the same difficult bar exam. However, the mean girling doesn't always stop. And there were definitely lawyers that would look you up on the bar website to find out where you went to law school to take shots at you about whether or not your law school was prestigious enough. However, by the time I got to that point in my life, I was like, please underestimate me. It will just make it easier for you not to see what's coming. But it took me a while to get there because I have a whole TED talk about having a big old chip on my shoulder. So we can talk about that later. I am going to look at this. But yes, the dick measuring of what law school you went to is alive and well. And Emily, it's just story time. You're never going to get through this. But I worked for a judge who I very much liked. A lot of lawyers did not like this judge. He was just, A, he had a photographic memory. B, he was no fuckery. And C, he was like, get your shit done. You won't have a problem with me. Go, 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 go. I loved him because he was so easy to predict. Emily, you sound more and more neurospicy every single day. Yes. He was so consistent. He didn't sugarcoat shit, which I'm like, by the time you're a grown-ass lawyer, you can handle it. You don't need a judge to hold your hand and tell you that you get a gold star. But you should get your shit done. And he didn't want anyone wasting his time. Loved him. But every time I came in to his office to sit down and talk with him, he would ask me about different professors at USC. And I'm like, Your Honor, every single time, Your Honor, I don't go to USC. I go here. And he's like, but you're so smart. I'm like, Your Honor. First of all, I can't afford USC law school. Let's be for real right now. Second of all, I'm really neurodivergent and have dyslexia and ADHD. So my smartness has nothing to do with what I look like as a student on paper. So yes, I am very good at what I do. But applying for schools and programs is not always based on what and who I am. It's based on what I look like on paper. So yes, you can be smart. People should not be judged by what institution they go to, because a bunch of them just bought their way in. I said what I said. I'm not a legacy to anything. So let us continue.
What was your well, at some point,
University
how long were you in the
of
office
Southern
before you got
California.
assigned to the homicide squad? Oh, homicide unit, I'm sorry.
I'm not sure that it's an assignment to the homicide unit. I would say the first homicide that I had outside of the realm of motor vehicle homicide was probably 2015, somewhere in there.
Okay. And let me back up a
10
little.
years in.
What type of training did the Norfolk County District Attorney's Office offer you in order for you to be able to comply with Rule 14 discovery?
Objection.
No, I want to know too.
Sustained.
Damn it.
So when you started
I'm not saying it's an improper sustain. I'm saying I'm curious.
at the Norfolk County District Attorney's Office, you sat in district court?
Yes.
Okay. And how many district court cases would you say you tried?
I have no idea. A lot.
More than 100?
Probably.
Okay. And in all of those cases,
That doesn't surprise me. District court cases are going to be misdemeanor and cases of lower severity. That doesn't surprise me that they're turning and burning trials. I would need a printout at this point to go over how many trials I did.
were you able to comply with Rule 14 discovery and turn over the discovery that was required under Rule 14?
Objection.
Sustained.
Let me ask you this. the hundreds of cases that you tried in district court, was there ever any allegation that you didn't turn over information?
Objection.
Overruled.
No.
Okay. And then at some point you moved to Superior Court. When was that?
Began working on Superior Court cases probably in 2006, full-time assigned to Superior Court in 2012.
Okay. When you say full-time assigned to Superior Court, what does that mean?
So what that means is during the interim period from 2006 to 2012, I had cases in
Both.
Superior Court, but I was primarily assigned to the District Court.
That makes sense.
So you were trying cases in the Superior Court, but you were still trying cases in the District Court.
Correct.
For those of you talking about the Karen Reed case, the Karen Reed case isn't a district court case. That's a Superior Court case. So he was being asked about discovery in the district court cases, which are misdemeanors and like lower seriousness cases. This is him being asked about cases that were from, now he's getting into the Superior Court, like the felony cases. So Jessica, I was a prosecutor over 10 years.
Actually, I still do that to this day.
You still try cases in the
And so
District Court
now
as well?
he's
I do.
Okay.
in both Superior Court and
But you
district
said
court.
sometime in 2012, you were assigned to the Superior Court. Does that mean
Correct.
you came here every day?
Correct.
Okay. And what type of cases were you assigned in 2012 when you became a Superior Court DA?
would be hard to-
Variety, pretty much ran the whole gamut. Narcotics cases, sexual assault cases, child abuse cases, breaking and entering, armed robbery, whatever I was assigned, that's what I did.
Crime.
How long after you got to the DA's office did you start trying what they call light felonies?
I don't understand the line of inquiry. Everybody who is in the DA's office is responsible for complying with Rule 14 and is expected to know the confines of Rule 14 and to comply with it.
Get it, Your Honor.
So the backstory here is not particularly useful. What I want to know is what
Happened in this
ADA
case.
Lally did in this instance.
Understood, Judge. In any event, when were you assigned to the Miles King case? And Brianna Gardner, I'm sorry.
That's the case now.
Probably within a day or two
A day or two of what?
of the shooting and the murder occurring.
Okay. And how do you get assigned in the district attorney's office? Do they email you? Do they call you? How do they do that?
Objection.
Overruled.
I received a call from the first assistant.
And who would that have been at the time?
At the time, that would have been ADA Lynn Beelan.
Okay.
So he's going through chain of command. So you've got the DA and then you've got you've got your top line, like management DAs. I don't know if in Norfolk they also try cases or not. It just depends on the office. So the defense attorney is asking, who assigned you the case? How did that happen? And he's saying this is a murder case with a co-defendant. They are talking about defendant Miles King. He got it within 2 days of the shooting. Here's what that tells me as someone who was a prosecutor. He had this from the beginning. So police reports would just be starting to come in. So he would have handled this case from the moment the very first police reports came in.
And did she tell you you were assigned to this homicide case?
Yes.
And what does that mean to you, being assigned to a homicide case? What does that mean?
I got another case on my desk.
Well, I mean, at that point, it was an investigation. So as far as
no one had
assisting
even
with
been
the
charged yet.
investigation, should charges arise, handling the prosecution from there out.
Okay. So once you get assigned to the Miles King, Brianna Gardner,
So he is assigned to the case before they even arrested anybody. The earliest stage of the case. There's no excuse to not have information then, because your hands are on it. It's not like it got dumped on your desk by somebody else.
case. Is there a policy within the Assistant District Attorney's Office in Norfolk County on how to gather information that's required under Rule 14?
Objection.
There's ethical obligations.
Overruled.
I don't know if you need a policy.
A specific policy, not that I'm aware of, no.
Okay, so there's no policy that you're aware of in the DA's office that
There's statutory obligations, though.
that details how to gather information. Is that what you're saying?
Not that specific to that, no. Not that I know of.
So how do you gather information, and how did you gather information in the King Gardner case that was required under Rule 14? What did you do?
Objection. Just specify what is. It's too vague.
Overruled.
Just
Question
answer.
is, what did you do?
So what I do,
And I think we can take it in chronologic order. We start at the beginning
Yeah, what
and then
did
we'll
you
have
do?
follow-up questions.
sure. So what I do is what I do in every case, depending on how many different departments are involved. In this case, there was a local department and state police involvement. So I would make appropriate requests for any and all information that they had, any information that, specifically I could outline or delineate as far as what I felt was relevant. And
Stop right there. How would you make those requests?
Typically what I would do is write out a formal discovery request, submit the form to any involved departments, and communicate either via phone or email to whoever the relevant party was that I was requesting discovery from.
When you say discovery forms, what do you put on? What do you put on?
Anyone who's in law school, law related, just write everything down. Write everything down. Send emails. They memorialize things with a timestamp.
The form in this case for Gardner and King?
Initially, it would be for any and all police reports, any and all photographs, any and all information as to who was present, lab reports, if they had access to fire department, run reports, any lab personnel that responded to the scene, so that I would have an idea as to whether or not there was testing that was going to be conducted or items have been recovered from the scene. Copies of any and all search warrants, including applications, affidavits, copy of the warrants, any returns.
And let me stop you there. Do you have a memory in this case of asking for all the information that you just told you normally ask? Did you do that in the Brianna Gardner and Miles King case? Did you ask for all of that information?
Yes, and just for clarity purposes, when I'm initially doing this, it's not the Miles King and Brianna Gardner case.
Because there's no defendants yet.
Correct.
Okay.
Well, and more to that point, Ms. Gardner didn't become a focus of the investigation until later on.
Okay. So while you were investigating without a defendant being a suspect, at least not initially, you asked which departments for this information?
The State Police, Norfolk County Detective Unit, as well as the Milton Police.
I can't hear you. What was the last one?
Milton Police.
Milton Police. Okay. So you asked Milton Police, you asked the State Police. Who in Milton Police did you ask, and who in the State Police did you ask to send information?
The Milton Police would have been, at that time, Lieutenant Michael Collins. The State Police would have been Trooper Michael Proctor, as he was a case officer, and Lieutenant Brian Tully.
Ding, ding, ding.
And so you have emails going to...
So for those of you that are like, Emily, I'm just coming in, this is a case not related to the Reed case, but we are dealing with the same parties, and we are dealing with a discovery issue that may be a Brady issue. So we are dealing with, is this homicide case going to get yeeted at the end of the day because of discovery issues? We're going to find out more what those discovery issues are, I'm sure, through questioning as we get to the specific things that aren't turned over. The defense is saying, hey, what were you doing to get discovery? He's getting discovery before there's even a defendant in the case. Who's the case agent? Proctor. Who else is involved in the case? Tully.
All three of them asking for all of the information that you just listed, which would be normal information that you'd ask in any case after a homicide. Is that right?
Yes.
And did let's just take Mr. Proctor, Trooper Proctor, did he respond to you?
Yes.
And what did he provide you?
At varying...
No, to the extent he recalls, he can testify.
So at varying times, there were different productions of material, whether it was what was available at that time. So initially it would have been just whatever reports were available at that time. Later on would have been photographs, video.
So how often would you say you emailed or communicated with the state police, and specifically Trooper Proctor or Trooper Tully?
AC asked a great question and said, that's weird, no having no suspect, but having a DA assigned. Not necessarily. It really depends on the unit and the case, because there are times you have a victim and you're like, this is a homicide case. We don't know exactly who did it yet, but this is a homicide case. So it really depends on the unit. The feds regularly, it is their almost always practice that the feds have a case before they have a defendant. Even if they have a defendant in mind, the feds will work up cases on investigation long before anyone's indicted, and those indictments are unsealed and they're arrested. So the feds start with the investigation and then arrest someone after they're indicted. It is very common in more serious crimes or in special victim crimes that you will have a DA assigned, just depending on how the office works. So it's not unusual. And then there are cases like a DUI where somebody gets arrested by law enforcement brings them in, and then a filing happens pretty shortly thereafter, that are a little bit different. But no, it's not unusual in a homicide case, because you were like, well, this is a homicide. Now we have to figure out who did it.
Regarding discovery in this case?
I cannot tell you how many times via email, but I mean, it was a
Go get your
constant
emails.
Conversation, particularly throughout the grand jury process as far as discovery was concerned.
Okay. So when you say a constant process, was there a time period where you asked for stuff and you didn't get it, so you were re-asking for it, or is it always new information that you're getting from the state police?
I think it would vary. I think there were certainly items that I probably had to ask for more than once, but there were definitely items that I had asked for and was provided promptly, and then moved on from there to either additional information or that avenue was complete.
So do you keep records of, I asked for search warrants, I asked for crime lab stuff, I asked for witness statements? Do you keep records when you receive that information to be able to check off to say, I got these things, they're no longer outstanding, and the rest of this is?
I mean, I keep records in the sense of a list of items I'm looking for. And obviously when I receive something, then yeah, that would get checked off the list as far as I'm not looking for that anymore because I have it.
Okay. So if you got a set of grand jury minutes from a witness that you know testified in front of the grand jury, you'd check that off your list?
Well, as far as yes, I mean, I was at the grand jury, so I know who testified at the grand jury. But as far as receiving the minutes, yes, I'm aware of the dates. And when I received the minutes, then that would check that off the list.
I missed, I think, a question and answer, one question earlier. I think the question was, do you keep records of what you requested? What was your answer to that question?
So records, as far as what was requested, I would always have, at least in some form, some sort of running list of items I was looking for. And then if I received an item, then that would be something that would be off the list. Now, that list would be obviously added to as information develops, and there might be additional items that I'm looking for.
And presumably because it's on the list, you've made the request?
Yes.
Okay.
And so you'd have, whatever's on the list, you'd have emails requesting that information. Is that right?
Yes.
Okay. And then if they emailed back, you'd have checks off of your list.
The thing about emailing, or at least thoroughly emailing, and lawyers do this all the time, where there's a phone call and then they're like, just to memorialize our phone call, and then you put it in an email and send the email so it's stamped. Even if you get behind on making notes in the file, you can print out your email and put it in the file. So there are so many ways to do this. A checklist is good. I think if I had to do it again, I probably would start with spreadsheets. I used checklist too, but I would probably do a spreadsheet so you can just copy and paste your spreadsheet for every case of, in each case, there's going to be things you're looking for. Police reports, video, photos, autopsy reports. Like there are things in every case. And then if that doesn't exist, if there's no video of a case, there's going to be no video. But now it's also going to be cell phones, digital extractions, social media, subpoenas, and things like that. A spreadsheet would just be so much easier. So I used checklist, but I probably would do it by a spreadsheet. So yeah, a total template, because there's things that are just standard. In criminal law, you're not dealing with things that are that wildly different. I mean, the case facts are different, but evidence is evidence. Lucky Hamster said, OneNote is beautiful for this. I don't even know what that is, but it sounds amazing.
You got whatever it was, maybe you were asking for 10 things and you got 5. You check those 5 things off your list. Is that right?
Yes.
Is there any other mechanism you used to document what you got from, just right now we're talking about the state police, Trooper Tully and Trooper Proctor?
I'm sorry, any other mechanism of doing what again?
Keeping track of what they're producing for you. Is it all just email?
Sherry, this is a great point. Sherry said, I'm pretty sure there's case management software. Not necessarily. Let me answer better. There are tons of different case management softwares that attorneys use. Most government entities do not have them and do not use them. So most government attorneys do not have that type of management software. the IT departments are like operating on hamster wheels and no budget and like glue. So you are often dealing with like a Microsoft suite of products that somebody bought in 2002 and you're hoping still gets updated. So it's just different. Then again, government tech is a whole separate issue. So we'll continue. And there are some things that you can't deal with on your work computer if it's not deemed secure enough. And you can't put case information on your private computer because if somebody gets into your private computer, there can be a huge information issue. So I could soapbox for days about how I think one of the number one places that any government at any level needs to put their money, but tech security should be first, and it often comes last because nobody sees it until it's a fucking problem. And then they look at their tech department and go, why is this a problem? And their tech department's like, bitch, per my last emails for the last 10 years, we have been telling you that this is an issue. And everybody went, it'll be fine. And then it's not fine. Y'all look at us, go, why is it not fine? We've been telling you. Shit's out of the horse now. Fix it before you need to.
Emails and check marks on a list? Or is there some other way that you keep track as well?
No, I mean, it would be something that I would have a list of items that are outstanding that would be, followed up on if they hadn't been received at that point, and then I would follow up with whoever the appropriate person was to get copies of those.
And these lists remain in the file? Your lists with the check marks remain in the file?
To the best of my knowledge, yes.
Okay. And have you reviewed any of them before you testified here today?
No.
Okay. Is there a reason you didn't review the file before you testified here today?
I don't have the file.
You work for the DA's office.
I understand that he doesn't have the file because it's been assigned to a new DA. Did you just not check so you don't know? Are you just willfully avoiding checking?
That's right.
I do.
That's me speculating. I'm not saying that he is.
Yes.
And you knew you were going to be asked questions about this case, right?
Yes.
And you didn't do anything to educate yourself about what you did initially on the case?
Objection. This is her witness.
Well, I'm not sure I agree with that as an objection, but I'm going to sustain the objection as to the relevance. He did not review the file. Next question.
So what did you review in preparation for your testimony here today?
I reviewed portions of the file. I reviewed some of the items that have been produced by ADA Hickman. I reviewed search warrants. I reviewed police reports. I reviewed, you were asking specifically as far as checklists or notations. I didn't review those, but I did review, I have portions of the file. I have access to the file, and I did review portions of the file.
How are you not worried about this?
So you did review portions of the file?
Yes.
Being called to testify in court as an attorney because they're alleging evidence, how do you not care? I reviewed portions of it. I just didn't. People aren't afraid enough of getting in trouble. I don't know. How are you just like, it'll be fine? We just need more neurodivergent lawyers. We see things differently and we're in a constant panic that we've forgotten something. So we're going to quadruple check.
Oh, yes.
You just didn't review your checklist?
No.
Okay.
How do you know when you turned over things if you don't have your notes?
In terms of
people don't just remember
the
that.
Milton Police Department, do you also have emails going back and forth to the Milton Police Department asking for certain documents?
Yes.
And who in the police, would that be Lieutenant Collins?
Yes.
Anyone else in the Milton Police Department were you looking for documents from?
On this case, I don't believe so, no.
And did you keep the same type of list that you kept for the state police of outstanding things that you were looking for the Milton Police Department?
Yes.
And what did you get back from the Milton Police Department? Do you remember?
Items of similar nature that they had access to as far as police reports, photographs. I don't believe Milton did any of the search warrants in this case, but other items of discovery, video that they recovered. That there's a litany of different items.
A litany of different items? Did you
Yes.
say? Okay.
He said
And
a
those would all
litany.
be memorialized by email? Is that how you did it?
Yes, that's, I think, what Mr. McGee attached as Exhibit 1. It's about 137 pages.
Of emails
Oh.
back and forth between the Milton Police Department and you?
Correct.
So the emails were turned over.
And so at what
that's
point do you know that you have all of, so other than, strike that. Milton Police, State Police, any other
Yay for that, I guess.
person or entity that you sought information for in this case?
Certainly.
I'm sorry?
Yes.
Who's that?
Be the Office of the Chief Medical Examiner, be the State Police Crime Lab. There were some items that were outsourced to Bodie Technology Lab in Lorton, Virginia, where they did some additional forensic testing pursuant to
That's the lab in the
DNA.
Reed
They have
case.
different methods that our lab does not.
I'm sure they use that lab regularly.
Milton Fire Department, I believe Fallon paramedics were involved in the transport of the victim, Mr. Simmons. That's all I can think of at this point.
Okay. And would you communicate with those agencies the same way you communicated with the State Police and the Milton Police via email?
For the most part, could have been a phone call on some of those
All right, so let's stop
issues.
there. If there was a phone call, how did you memorialize what you requested and what they said in a phone call?
Notes.
You have individual notes.
Yes,
And where would those notes be right now?
in the file.
Okay. So do you keep like a running page of all the notes that you've taken in the case with communications that you had with all of the other entities and officers in State Police in this case?
Not all in one location, but it would be sort of divided up by different entities as far as what I was requesting from that specific entity and what I was looking for, what I was still waiting for, what was still outstanding, things of that nature.
Okay. So what happens when you ask for something, let's just say from the State Police, and they don't give it to you? What's the next thing you do?
The next thing I do would be to ask for it again.
Okay. How many
How long
times do
does
you
that go
ask
on?
for it before you have a meeting with the State Police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual.
Excuse me, sir, what's the legal grounds for the objection? Objection, Your Honor, we're not asking the questions I like. That's not an objection. Where are the legal grounds? Vague. Relevance. Like where? Objection, Your Honor. So what I'm feeling is that we're not on topic.
For it again.
Okay.
I had to back
How
it
many
up.
times do you ask for it before you have a meeting with the State Police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual date, vague questions about
Yeah, this is general practice, generally Mr. Lally's practice.
This is needed. What is your practice?
I think part of the issue here is we don't have very specific items that are being referred to.
Right.
But I think I'm going to overrule the objection and give
Whatever
Attorney
it is.
Scapiccio a little bit of leeway here in terms of general practice.
Right. What is your general practice?
So in general, how many times
What is your
do you
system?
email for the same document before you go to the State Police and start to have a sit down with them?
I think it varies. I think it would be depending on a lot of different factors as far as
I mean, that's fair.
what the item is, what the explanation is for why I don't have it yet, whether it's not available or whether it's something that they're currently working on, or if it's something that I know has been completed and I've asked for it multiple times and I still don't have it. I'm not saying that even happened in this case, but if in a general practice, if that were something that were going on, then yes, I would want to sit down with somebody and figure out exactly what's going on.
Okay. So let me ask specific questions about this case. When you reached out, let's start with Trooper Proctor. In this case, looking for information, and there were emails back and forth. Were there any occasions where you did not get the documents or the information that you were seeking from Trooper Proctor?
I don't recall anything specific other than if it was a situation where I'm looking for a report about something and that
I don't
report
recall,
hasn't been completed
but-
yet, or that item hasn't been obtained yet for whatever reason. But I don't recall in this case ever asking for something and just not getting it.
do you remember asking Trooper Proctor for the search warrants that he did in this case?
Yes.
And the affidavits accompanying the search warrants?
Yes.
And did he provide them to you?
What I received was a partial affidavit for search warrant.
Copy that. Did he provide them to you, yes or no?
Some.
How many search warrants do you recall there being in the
Yes or no?
City Gardner
Some.
case?
Do they still not have the search warrants 4 years later? Because the search warrants, once they're done, like the search warrants are done when they're signed by the judge. And then the search warrant returns come a little bit later, but not much later, because search warrants like expire, they age out. So you get the search warrant and the affidavit, a judge signs it, they get served, you turn them over when like the case gets filed, because you generally have them when the case gets filed. And then if the search warrant returns haven't come in yet, then you turn over the search warrant returns when they come in.
In 2021 or beyond?
2000, let's start with 2021. How many search warrants? You guys pulled the search warrants?
6.
Six.
Did he, when you asked, and he signed all 6 search warrants, is that fair to say?
That's my understanding, yes.
So
Okay.
Trooper
And
Proctor
so
did 6 warrants.
When did you ask Trooper Proctor for the search warrants?
I mean, when the case gets filed.
In July or August of 2021 when they were filed for.
Okay, and when did you get all 6 search warrants from Trooper Proctor?
I didn't get all 6 search warrants from Trooper Proctor.
What?
You did not?
I did not.
Okay, so
He asked for the search warrants. There were 6 of them from Trooper Proctor in July or August of 2021. When did you get them? I didn't.
did you get 1 search warrant from him?
From him specifically, I received a portion of the affidavit for search warrant 306 and the entire affidavit for search warrant 348.
Okay, so you got portions of 2 search warrants, and you knew there were 6 search warrants, is that right?
The affidavit's not the whole search warrant. The affidavit's only part of it. And how do you get half of an affidavit? If somebody gives me half of an affidavit, my response is going to be, what the fuck is this? How do you get half of... What does that even mean? Half of an affidavit. But there's a search warrant and an affidavit. What?
Yes.
Did you make notes?
For all of you in the chat saying it's a half a David, 10 out of 10 law nerds, the wit never disappoints. I'm buffering. I had to back this up and hear the questions in full. I'm so confused.
Entire affidavit for search warrant 348.
Okay, so you got portions of 2 search warrants, and you knew there were 6 search warrants, is that right?
Yes.
Did you make notes somewhere in your file? Geez, I asked Trooper Proctor for these 6 search warrants, and he hasn't given them to me yet?
I believe, yes.
Okay, those notes are in your file?
I believe so, yes.
Okay, and then when you didn't get the search warrants from Trooper Proctor, did you meet with him?
Yes, I mean, specific to that, I don't recall any specific meeting related to search warrants, but we did meet several times in relation to this investigation in this case.
But you understand that search warrants are Rule 14 automatic discovery, right? And you knew there were 6 search warrants, right?
I did.
And so when do you realize that you don't have all 6 search warrants? How long into the process? Do you know right away you don't have them all?
I
Or do
mean,
you not know for a long time you don't have them all?
obviously.
I don't think I realized at that time that I didn't have them all.
How?
So how, then I guess I'm confused about how.
You know there's 6 and you have like parts of 2. I don't even understand what you mean you don't realize it. That doesn't even make sense to my brain. You don't even have a full search warrant. You don't even have one full search warrant. When did you realize you didn't have them? I didn't realize. What do you mean you didn't realize? You knew there were 6. You knew you didn't have even one full search warrant. Also, search warrants are one of those things that they're just, once they're signed and served, they're done. There's nothing else that needs to be done with them other than turned over, because one of the first types of motions that defense attorneys file in motion practice to keep cases moving along is motions regarding the search. Like it's one of the early stages before you go to trial is attacking the search warrants and attacking the search. Like this is part of the process. Like it should be law enforcement's process that with the initial case filed, those get turned over. More search warrants can be done later, of course, and then those get turned over when they're done. But this just gets turned over at the beginning because they're being done at the beginning. Even if they're,
How your system works. You said you had a system where if you asked for something and you didn't get it, you would then follow up with the police officer asking again and again. Did you do that with Trooper Proctor in this case with the 6 search warrants?
Yes, I believe so.
How many times did you email Trooper Proctor asking for the 6 search warrants?
I don't know.
More than 10?
I don't believe so, no.
Okay. How far in between each email? Did you wait a month and email him again? Did you wait a week? Did you wait a day? How long in between your...
I can tell you how this went. Every time this came up in court, he went to court and went, oh shit, I don't have those yet. Hey, buddy, can we get these? He wasn't doing work on this case in between, it doesn't seem. It seems like he would go to court and be like, oh, oops, still don't have those yet. I guarantee you that's what happened.
Request to Trooper Proctor to produce the 6 search warrants in this case?
I don't know.
You don't?
No.
Did you review your emails before you came here today?
Some of them, yes.
Some.
Did you see any emails to and from Trooper Proctor regarding the search warrants?
Yes.
How many did you see?
I don't recall.
More than 5?
Yes.
More than 10?
I don't know.
What are the dates of the first time you asked Trooper Proctor for the search warrants?
Specific date, I don't know.
How long before the next time you asked him for a 6 search warrants?
Specifically, I don't know.
Was it months or weeks?
Weeks.
Weeks later. Okay,
Yes.
so that's 2 times you asked him. What about the third time? How much time went by?
I don't know.
Months or weeks?
I don't know.
What about the fourth time?
Again, I don't know how many times and I don't know specific dates.
So I guess my question
Where are
is,
the
how
notes?
does your system work if you're not getting the discovery that you're asking
He
a
doesn't have a
police
system.
officer for, and you're asked for it, let's just say 5 times?
Counsel, you keep calling it a system. I have a feeling it's on vibes and I haven't gotten yelled at about it yet, and the court hasn't ordered me to turn them over and screamed at me, so they're not getting turned over. This is wild.
What do you do? Do you go to the office and you sit down and say, give me these search warrants, I have to turn them over?
Yes.
You did.
Yes.
And
Did you do that in this case?
Yes.
You go to Trooper Proctor and say, give me the search warrants because I have to turn them over.
Yes.
When did you do that?
Sometime prior to the defendant's arraignment in December of 21.
November of 21, did you say?
December of 21.
December of 21. So when you get to his office, do you go there or do you tell him to come to your office? I don't know how that works.
Either.
wait. You started asking for search warrants in, I made a note, July or August of 2021, which means that's probably closer in time to when the murder happened. And then the arraignment after the grand jury happened in December of 2021. Are you telling me that you didn't read the search warrants before you went to grand jury? Because when you file a case or grand jury a case or prelim a case, you have to review if there's any serious issues with the warrant, because if there's serious issues with the warrant, you have to then make the decision about whether you bring the case or not, or if new warrants are needed or whatever. Like, What? So he asked again before December of 2021, before the arraignment, which means the grand jury was before then. How do you file a case without reviewing the warrants? Because if the warrants are fucked, you don't have a case. And you can't just like vibe it. What are we doing?
I don't
Remember
remember.
how you met about the search warrants the first time?
The,
In other words, did he come to you or you go to him?
I don't know.
Okay. So you have a sit down
Yes.
and you ask him for the 6 search warrants. And what does he say?
He will get them to me.
He will get them to you.
Yes.
Okay.
Trust me,
And
bro.
you tell him I have an obligation to turn this over because it's Rule 14 discovery. I need it right away. I've asked for it 5 times. What's the deal?
Those specific words, no, but the gist, yes.
Well, tell me what you said specifically.
I
He
don't
doesn't
know.
remember.
Well, give me a best estimate of what you said to Trooper Proctor after you asked 5 times the
Objection.
search warrants that he didn't turn
You
over.
got those warrants?
So,
Where are
did
the
you keep any
warrants?
notes of your conversations with Trooper Proctor when you were asking for these 6 search warrants that he didn't give you?
No.
Why not?
It was something that I knew that was outstanding. It was something that I had asked for in written form numerous times. I didn't feel the need to write a note that I asked for it again.
So that's the first sit down. Did you send emails after the first sit down saying, hey, you promised me you're going to send these 6 search warrants, I still don't have them?
You work in the same
Objection, assuming
office.
facts.
Overruled.
I'm sorry, could you repeat the
Did you
question?
send another email to Trooper Proctor after you had the sit down at sometime in December of 2021 saying, hey, you still didn't send those 6 search warrants, can you send them over?
Yes.
How far after Mr. King's arraignment in December of 2021 did you send that email to
He has no
Trooper
idea, I'm
Proctor?
sure.
I don't know.
Was it a year?
I don't think so, no.
What do you think? What's your best estimate of when you sent that
He doesn't
email
know.
after you sat down with Trooper Proctor?
I would say probably a few months later.
All right, a few months.
Yes.
So February, March of 2022, is that what you think it?
I don't recall specifically.
So when you're in this room with Trooper Proctor asking about the 6 search warrants, do you ask him for his file? Like, give me your whole file so I can go
Yeah,
through
let me
it
see it.
and figure out what's in it?
No.
Why not? You're there. There's outstanding discovery. You have the obligation, not the police officer. Why don't you ask?
I entrusted that whatever discovery I was requesting, I would get at some point in a timely fashion and then turn it over.
But you didn't get it. You asked for it 5 times.
But it's already not a timely fashion. I trusted I would get it in a timely fashion. It's almost a year later. Timely has fucking passed. You'd get it to me eventually. Like, what? Also, from what we saw in the Karen Reed case, no, he fucking won't get it to you eventually. He'll just get it eventually. He'll just get it eventually. How are people out here doing their job like this? It'll be fine.
You didn't get it. You had to go see him. You have him right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
And when he says you'll get the search warrants, I'll send them to you. Did he have them? Did he have copies of the search warrants? He just wasn't giving them to you?
That I don't know. You'd have to ask him.
Well, you don't get the search warrants in any event after that sit down, and you send another email.
He's like, I'll get it eventually.
What's
It's fine.
Trooper Proctor's response to that email?
Again, I don't know that I sent another email, but I know that there were subsequent conversations about it. Whether it was what format it was in, I don't know.
Okay, and at this point, you have to be getting a little upset with Trooper Proctor that you're asking for information that he's not giving you, right?
Objection. Overruled.
I'm sorry, your question again?
You have to be getting a little upset at Trooper Proctor that you're asking him for information that he's not giving you, right?
Ma'am, I don't think he gets upset. I think he gets paid the same way no matter what. He's like, it's 4. See you guys tomorrow. I don't think he gets upset. I think he's like, it's fine. The judges in Massachusetts need to start fucking fining people. They need to start throwing out cases and fining people. It's the only way it's going to change. You need to start fining the DA's office. Monetary fines. Report to the bar fines for not turning over discovery. Because if this can go on for years with no teeth or consequences, the defense bar must be losing their minds. Or the defense bar is glad that this is finally all coming forward so that other judges see what a problem this is. Because if the defense is saying the discovery hasn't been turned over for years, these hearings shouldn't take 4 years to happen. And if the DA is saying, Your Honor, law enforcement's not giving it to me, fine, let's have a hearing. Put their butt in the seat and tell me where the fuck it is. Put law enforcement in the seat and tell me where it is. And then find the DA's office. Once attorneys have to start reporting themselves to the bar, I imagine the conversations they have with law enforcement will change. But if that doesn't, if in the Kohberger case, for example, the DA was saying that they were having trouble getting things from the FBI.
The FBI!
And the court said, do you need a court order or do you want a hearing? And the DA said, give us like a month and then maybe. Because if you're not being responded to, the court will help you. Your Honor, give me a court order and a subpoena. Bring them in, they can explain it to you. I've asked, this is when I've asked. Do it, let's go. But until the judges throw the hammer down, and not all judges want to, but until the judges throw the hammer down, even if it's not the DA on that case's fault, it doesn't matter because it is their fault. It's your responsibility. And if the DA who threw the case on your desk before you didn't do it, it's still your responsibility because now your name's on the file. And the only way the culture is going to change is if the judges throw it down. This hearing is happening after 2021. However, the defense attorneys, it seems, now have their work cut out for them to review their cases and their cases that they have on appeal. And so the courts are going to get real busy. You know what judges don't like? When their courts get real busy. The courts are going to get real busy with, hey, it's time to take a look at this. And the defense attorneys, I'm sure they already are just going to file motion after motion after motion and hold everybody's feet to the fire. Because if this is what's going on, we're way more than a non-zero. If this is what's going on in the cases we're seeing, what's going on in every other case? The defense bar should just start throwing paper at every single fucking case, which is a lot of work. And the judges will get annoyed, but too bad. If the discovery gets turned over, it stops. This is crazy. There's just, this is just basic.
Right?
How do you grand jury a case if you don't have the discovery?
Frustrated, probably.
Oh, he said he was frustrated. He's like, I was probably a little frustrated. Sure.
That a trooper proctor that you're asking him for information that he's not giving you, right?
I was a little annoyed. I was miffed.
Say upset, frustrated, probably.
I'm sorry?
Frustrated, probably.
Oh. Judge, can we approach sidebar just briefly? I know.
Sure.
Sidebar?
You still don't have the 6 search. In any event, ADA Lally, a couple of months goes by, you still don't have the 6 search warrants. What do you do?
I don't know.
He's buffering.
I specific to the 6 search warrants, I don't recall as far as there was a topic that was discussed repeatedly. Obviously, I never received them because I never provided them to you or to Ms. Costa.
Okay. So I guess what I'm saying is you knew they existed and you knew that, let me just say this, you knew that all six search warrants existed. Is that right?
Yes, we went through all six of the.
He's like, IDK. Don't go to grand jury until you have it in your hand. Then guess what? If you won't grand jury a case until it's in your hand, then it gets stuck on the cop's desk. Why haven't you made an arrest? Why hasn't gone to grand jury? Well, the DA won't grand jury it until they have all my shit. Okay. Don't grand jury it till you have all their shit.
The search warrants on the last day of the grand jury presentation on November 19th, 2020.
I'm going to back up to that answer. I mean, that's there. It's not hard to hold people's feet to the fire in this. You have it or you don't.
Okay. So I guess what I'm saying is you knew they existed and you knew that, let me just say this, you knew that all six search warrants existed. Is that right?
Yes, we went through all six of the search warrants on the last day of the grand jury presentation on November 19th, 2021. That's in the grand jury minutes as far as going through each of the materials, each of the search warrants, that they were search warrants, how that material was obtained, and the material that was returned in response to three of the search warrants was marked as grand jury exhibits 33, 34, and 35.
You went through all six search warrants the last day of the grand jury on November 19th, 2021. And you still didn't have them in your hand and turn them over by December? Like, by December is generous. But like, your officer has them. Where are your grand juries? I mean, they're not on fucking Mars. Go back to the office with at least a photocopier, which I'm sure your office has. Put that shit on the copier and make 3 copies of it. And then give it to the defense at arraignment in December. The arraignment's in December. What?
Right, but not the search warrant.
Correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So, with
Sounds like it. That sounds like
and I'm
it.
trying to. So,
Okay.
with regard to those
Don't get snappy at the defense attorney. She asked the reasonable question. She has every right to be pissed. Don't get snappy at her like she's overreacting. You're underreacting. You put information from search warrant returns in front of a grand jury and you had never seen the search warrant. That's exactly what she asked. And that's exactly what you did.
Right, but not the search warrant.
correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So, with
Answer that
the
question.
and I'm trying to. So,
Okay.
with regard to those 3 search warrants, that was 306, 307, and 329, which were the call detail records for your client, the victim, Mr. Simmons, and Mr. Jeanette. The materials that came back from the cell phone providers also contained a copy of the warrant, as well as the addendum to the warrant, which was then also provided to you and Ms. Costa in discovery.
But not the warrants themselves.
No, the warrants themselves and the addendums, not the application and not the affidavit.
Right, so you understand that in order to make
You can't make a motion if you don't have the warrant and the affidavit, though. It doesn't matter if you just have the addendum.
a determination as to whether or not you're going to suppress certain information, you actually need what you asked for and what you, in the affidavit that told the clerk magistrate why you had.
Hillary was like, why are we doing this? Because we like pain. Because the law nerds asked. Y'all asked if we would go over this because, again, I said the entire Reed trial, this shouldn't be happening. And now we are seeing how deep it goes with discovery not being turned over. This isn't how this is supposed to work. And a lot of you wanted a prosecutor's perspective on what is supposed to happen on the other side of this case when you're the prosecutor. And once I stop buffering, I hope to explain, but it doesn't seem like the ball was dropped on a case. It seems, and I'm sure if anyone who works with hundreds, if not more cases, there will be cases where stuff goes sideways. It will happen. But when it is the exception, well, then the case gets dismissed generally if shit goes that sideways. But it seems like we never had a ball. Like, we don't even like have a floaty. This seems to just be the way it is. This doesn't seem to be oh, shit went sideways in the Reed case. It seems that this is how cases are handled, which is baffling. Because the rules don't seem to mean anything. And if the judges aren't throwing down consequences, which I think they should start to do if they haven't, then you have people sitting in jail for 4 years plus waiting for a case to go to trial, and their defense attorneys don't even have all the discovery. Which means that people who commit crimes and maybe should be separated from society for a bit aren't going to be. But people who shouldn't be in custody because the search warrants weren't proper or the case is super weak or it shouldn't have been filed sit in custody forever waiting for that to be sorted out too, which shouldn't happen. It's bananas. And the defense attorneys, I'm sure, have been screaming this in court for years, feeling like they're banging their head against the wall. Because these are not unusual requests. This should just get turned over. You have to do your job correctly. So this just is more and more seeming like an office that is just like meh. And if you're just going to be mad, then stop charging people. I mean, and the residents of Norfolk County aren't going to like that. But the residents in Norfolk County have an election coming up in 2026. But also, this is not just on the DA's office, it's also on the judges. If the defense attorneys are telling you, we have asked for the search warrants for 4 years and the judges haven't said, go write a fucking check. Because when you get fined, it doesn't necessarily fix things, but you have to report it to the bar, and then at least there's tracking of the fuckery. Bring everybody in and put them on the stand. All the time. It's going to take more time. Bring them in and put them on the stand. Explain to me why this didn't get turned over when you had it at the grand jury. I'll wait. And if the office is getting fined on every single case they file, shit will change. Wild. This does not seem like someone dropped the ball. This seems habitual. Because Attorney Lally can't explain what his practices are for making sure stuff gets handled. He can't sit down and explain to you, in every case, I do this way. And lawyers might do it differently. Everyone has a practice of how they do things to make sure everything in their case gets handled appropriately and well. This is wild. Wild.
Had probable cause, right?
Objection.
I can take judicial notice of that, and I'm sure Mr. Lally knows that.
Okay. So you get in front of the grand jury. When do you present this case to the
That was Attorney Lally with a Canoni sigh.
grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
In 2021?
Correct.
Okay. So at some point when Mr. King is arraigned, you understand at that point, Rule 14 kicks in, right?
Yes, I mean, I'm thinking about Rule 14 well before that.
Okay.
Are you?
And you know, when you arraign Mr. King, you still don't have the search warrant. You have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over.
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then, remember at some point in December of 2021, receiving a discovery notice from me. Hey, Prosecutor Toronto.
Yes.
This is just my discovery notice.
The defense attorney's like, just in case you need to see it, here it is, because you reviewed fuck all before we started this.
Is that a discovery motion or what is
Motion,
that?
I'm sorry, motion, Judge.
Yes.
Okay. And do you remember, after having filed this motion, you asked the time to go through and make sure that you can comply with all the requests, right?
Yes.
And you didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Well, it's not objectionable.
May I approach the witness, Your Honor?
Yes.
It's not.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge. I can,
You know what it is?
This is just shit that gets turned
I
over.
think it's,
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. So
All right,
I wanna
so-
mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14? Okay. And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible.
document speaks for itself.
Okay, that's fine, Judge. So after I filed this
The judge is like, I know what Rule 14 is. He said he knows what Rule 14 is. We're all on the same page. Let's get to why it wasn't turned over and when.
motion to December
We
of
all know.
2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there is any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
Excuse me. And did you do that in this case? Did you send my motion for discovery to Trooper Proctor, to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion.
Then what
You're
happens?
looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until you get an answer from them?
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
And after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email, or do you get in your car and drive down there and say, we got to end this, give me this stuff?
If they work in the Norfolk DA's office, isn't your lead investigator there? And isn't your lead investigator the one you go to? And well, in this case, it was Proctor, and say, hey, this other department hasn't gotten my shit. Can you get in a car and go down there and have them physically hand it to you? Please? Thanks.
Email or a phone call.
Okay. And so did you email a phone call, make a phone call to Trooper Proctor in this case?
I'm sure I did.
I don't have enough
And
lip gloss
what was
for
his
this.
response
I don't
when you
recall.
asked for the 6 search warrants?
He knows he doesn't recall.
I don't recall.
He's like, what I know is I don't know.
Well, do you have any notes of your conversation with him? Remember you taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue, that you wouldn't take notes of what Trooper Proctor told you about the search warrants?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the six search warrants?
I'm sure I did, amongst probably a number of other items.
Okay, and then you knew this case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, I have these 6 search warrants that Trooper Proctor has, I can't get my hands on them, can you issue an order or can you help me out here?
Did I do that? No.
Why?
So when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay. But you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
I'll just keep asking. I'll just ask
But
until
you
it
did
magically
that. You
appears.
requested it 5 times. You went to see him. Then you got my discovery motion. You sent that to him. You waited another month. And then what happened?
I don't recall.
Well, don't you tell him, get me these things now. I'm coming down your office?
Objection.
Overruled.
Did I ever tell him that? No.
I mean, something along those lines, no.
So what do you do when he's not complying with your request? Let me ask you this. What's the policy in the office of the District Attorney's Office in Norfolk
there
County
probably isn't one.
when a state trooper is not complying with a request for discovery?
Objection.
There probably isn't a policy.
Overruled if there is a policy.
What's the policy?
I don't know any specific policy related to that.
Okay. So do you go to your supervisor then and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection.
Overruled.
Not that I recall, no.
Okay.
Really? You've never had another case where discovery has lingered and you haven't gotten search warrants? She narrowed it down to search warrants. Really? Hard to believe.
Your Honor, may I be heard on one slight issue? The discovery that the discovery request the counsel is speaking to, I don't believe that it was ever docketed. I don't have a copy of it. I've never seen it. So
The motion, the motion?
The motion for discovery was filed. He got.
Well,
it may not have reached the docket, as I guess.
I want to make sure that you see it, though. Let's make sure you...
Speaking about it a lot here, and
No.
I've never seen it.
Attorney Scapiccio, can you just give it to Mr. McGee for a second?
Sure. You think it would be in the file?
I would think it would be in a file. Is that a clean copy?
That is a clean copy, Judge.
Can we mark that? Should we mark it?
The judge is like, I would think these requests would be in the file. Yeah, they should be.
Oh, the non-signed, all right, so let me get you a signed copy, Judge.
I don't know what was.
The bottom line is, this witness said he received it, Judge. I know I wouldn't have not filed it. We talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion and the court had it.
All right, we'll
In front of it.
figure that out.
Can you guys put the transcript?
We do have ADA Hickman did have a copy.
You do have a copy?
I never saw it on the docket. I was working right off the docket.
Okay.
So,
And just so the record is clear, we have marked it? You want it marked as Exhibit 1 in this hearing?
yes, Judge.
Sure.
All right.
I'll get you a signed copy, apparently.
All right, that will be Exhibit 1.
Thank you. I'd also, at some point, Judge, like to mark the pretrial conference report in this case.
It should be. The court should have it.
So this had never happened to you before, Attorney Lally, and You didn't go to Lynn Beelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't think he had a
I
plan.
don't recall specifically having a plan. If there
Right.
was a situation where I was asking
Ask again was his plan.
a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved as far as saying I've asked for this a few times, I don't have it.
Okay, so let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
It's not your job to protect state troopers. That's not your job. You're not their lawyer. You're not their in-house counsel. It is not your job to protect them. It is your job to do your job as a prosecutor, which means adhering to the rights of the defendant while protecting the public. You can't do that if you're not turning over discovery. It's not your job to not hurt the state trooper's feelings. And of course, the supervisor is Tully.
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
But as you sit here today, you don't remember going to a supervisor, is that right?
I know that there were a number of meetings in relation to discovery that Lieutenant Tully was present for, along with Trooper Proctor, but going specifically to his office to demand 6 search warrants, I don't.
How the fuck is this happening that there's a number of meetings with Tully and Proctor and who the fuck ever, and it's still not getting turned over? Didn't Tully just look at Proctor and be like, your paper case file, pull them out and copy them? I don't even understand how we're I don't understand why this is hard and not getting done. Just
recall that.
Okay. So how much time goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, you fair to say that we were appearing in court every couple of months
the
on
meh
discovery, right?
is wild.
Yes.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Wasn't the judge annoyed?
Okay.
Wasn't the judge like, where are the motions to suppress? Why haven't we done these yet? We know they're coming. Like, what? Aren't those done early on in the case? Like, you know, if the judges prevented the district attorneys from using discovery at trial that wasn't turned over, and all the defense attorneys said we're going to trial within the period, and the DAs weren't allowed to use anything that wasn't turned over, things would change immediately. But you would have to block them from using evidence that wasn't properly turned over. You would have to block them. And the defense attorneys are like, we're not waiving shit. Go within the trial. And then shit would change. Your Honor, we just got this new report. I don't give a shit. You didn't turn it over. I don't care if you have a new report. Dismiss the case then. Go to trial another time. Turn it over.
Now, you talked about having meetings, discovery meetings. Tell us what those are.
You know, at various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to, this is the discovery that's outstanding, this is what I'm looking for, what's the ETA on this, when should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So whether it was
Right.
my end of the hall or their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants are still ongoing, as some of those search warrants were not just July. I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but.
What do you mean they're ongoing? If they've got returns, turn them over.
So how many motions or how many meetings do you have regarding discovery before the return or before the return of the search warrant in July of 2021, if that's the date?
Not many. I mean, the murder occurs on July 10th, so there's not a lot of time in between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track?
I can't figure out
if you
either.
have this list that
Ma'am,
says
I'm buffering
all these
with
things
you.
are outstanding, and you're having these meetings because there's things outstanding. If you're not taking notes at these meetings, how do you know what people are saying and when to expect the discussion?
So if there was something that specifically was known as far as, this is what's going on with this piece, and an anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
You can turn it over before the return's done.
So let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again?
He's not indicted till November of 2021.
For the search warrant, so you still don't
We've
have?
been over this time period. I'm trying to
Yes.
figure out some.
Yes.
You went all the way through arraignment and on the number of meetings and
What
emails
happened
back
past
and
November 19th, 21?
forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, let me ask a question. So
The defense attorney is also buffering because it's like, how is it this bad? What happened from arraignment through court with all the discovery motions? I get where the defense attorney's at. The defense attorneys are like, are you fucking joking me? How is this bad? And the court is like, he didn't have them. He doesn't know. What happens from November 19th, 2021 forward?
when do you realize that you never turned over the search warrant? When do you realize that?
As far as the 2021,
Back up. When do you get the search warrant in your custody?
in my custody,
Yes.
I would say probably I became aware of it about a month ago.
In 2025.
Yes.
July of 2025.
You grand juried the case. How are you not aware of search warrants? You said there were 6. What does that answer even mean? I became aware a month ago. When did you turn the case over to the other DA? You knew there were 6 search warrants when you grand juried the case in November of 2021. When did the case go to a different DA? Because he's not still the DA on this case. So I have grace from the time he was off the case till now. But when was he off the case? Because at that point, he should have known that there were no search warrants turned over. This is bananas. But I want to know when he handed off the case.
June of 2025.
Yes.
Is the first time you became aware that you didn't turn over the search warrant?
Yes. If I had been aware earlier, then I would have turned over the search warrants.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then when did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
When was
Let's
that?
talk about that. What date was the case transferred from
Thank
you to ADA Hickman?
I'd say probably somewhere in October or November of 2024.
2024.
Yes.
And how does the case, let me just say in general, how does the case get transferred?
You grand juried the case in November 2021. You turned the case over in November 2024 and the search warrants hadn't been turned over then? What? How? Also, how did a court, because I'm sure the defense attorney was in court every single time going, but Your Honor, we still don't have discovery. How did this hearing not happen a year in? If you don't have the search warrants that were at the grand jury a year in, how are you not having this hearing? 6 months in, how are you not having this hearing? How is no one afraid of these judges? There seems to be no concern at all. Y'all need to start fining people. What are we doing? Because some of this, if the defense attorneys are saying, and I'm sure that they are over and over and over again, I don't have. At what point does the judge turn to the district attorney and say, get your officer in here and explain to me where this is, or I am fining your office $5,000 and you can report yourself to the bar? Why is that taking 3 years, 4 years, 5 years?
From one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what
Holy
needs to get
shit.
done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
I just gave
So I
it to her.
physically took the physical file from my office to ADA Hickman's office.
Okay. And did you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Trooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
But then at some point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Say that to you?
No.
She never did.
Nope.
Did you ever have a conversation with ADA
Nope.
Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay, and what transpired?
Objection.
Sustained.
Well,
The
So-
sighing.
when you told the court that discovery was almost complete, did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I've stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025.
Like, how do
That
you
statement was
just
never
not
made.
care?
So,
That's
and
why
then
I want a
December
date. That's why I want a date.
and October as well, when Your Honor set this for trial. So thank you.
So, when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
That's a
January 2024?
big
So let me back
difference.
that up. In January of 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm sure there
Okay.
were.
And do you remember, excuse me, do you
Why does
remember
nobody care?
the court asking about discovery and how the discovery was proceeding?
I'm sure it happened. I don't recall that specific date or what was asked.
Okay. And do you remember telling the court in January 2024 that you were hopeful that
I don't think these judges have enough work to do, because in busy counties, you can't have cases lingering on your docket for 3 years for discovery. Obviously, nobody's busy enough. Everybody needs more work to do. But if your docket is full, you have to get the discovery done so cases will keep moving. How does nobody put their foot down? Because the defense attorneys aren't being hyperbolic in this. If the defense came in 3 weeks later and was like, Your Honor, sanction the attorneys, we don't have any discovery, that's a bit much. But how do you get to 6 months and not have the initial search warrants? That's appalling. Because you have to start getting the motions done. This is not how this should be happening. This is not how this should go. And I know the defense attorneys are jumping up and down going, this is not what should be happening. But the judges have to throw down consequences. And there should be. The law is there for a reason. And if you don't follow the rules, there are consequences. It's not just like, meh, it's fine. Do the judges not look at their list of how old their cases are? Are they not embarrassed? Like within the county, are they not looking at their like 90 days, 6 month, 1 year, 2 years and just being like, why the fuck are your cases so old? Like, everybody's just like, I get paid the same. I get paid the same. I do not care. I get paid the same. I get paid the same. It's 4. The apathy is just wild to me that he's just like, it's fine.
That by March of 2024, we could proceed forward because discovery would be complete. Remember that?
I don't.
Okay. May I approach the Mr.
Yes. It's from when? That wasn't able to do that.
January 2024.
I know. Show you the.
And y'all, I see a lot of questions, but in Massachusetts, unless their rules of criminal procedure have been overturned, Rule 36 is 1 year from the time of arraignment. But if the defendants are waiving that time, once it's waived, then it's whenever. But it's 1 year from the arraignment. So there is a federal right. That is a constitutional right. But if the defendants waive their right for some reason, then that can go from 1 year to 4 to 5 to... I wonder if the defense attorneys have stopped waiving time. Just stop waiving time. So.
Request.
It's wild.
May I approach the Mr.
Yes.
I'm going to give you the transcript of
It's in their criminal
the
rules.
hearing before this court on
Massachusetts Criminal Rule of Procedure 36. Unless Rule 36 has been overturned by case law, which I don't see. Criminal Rules of Procedure 36. 1 year. Unless there is an exception.
January 24, 2024, and ask you to look on page 5 and tell me, read that at the bottom of page 5 to yourself and the top of page 6.
In some cases, it's 2 years, though. There is a provision for 2 years.
Yes.
Does that refresh your memory as to whether or not in January 2024, you told this court that substantially discovery was complete? There might be 1 or 2 items that are outstanding, but can you get them to us?
I didn't read that portion. I was reading the highlighted portion. If I could have a moment.
Sure.
I'm sorry, I'm not seeing what you're
It's
referring
wild.
to in that
Well, do you remember
transcript.
telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines 16, 17, and 18 on the document that's in front of you, Ms. Lally.
And what page, Ms. Attorney?
Page 4, lines 16, 17, and 18. The court asks, where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry. In the transcript that you handed me,
seems to say
I don't
that.
see that.
Let me see, it's a different one. Do you remember, hold on, let me get this right.
Well, they are buffering. I'm pulling up the criminal rules in Massachusetts to see if this has been overturned by statute or overturned by case law.
Do you remember telling the court, I was wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces, talking about discovery, that I'll check on, and some other pieces that I was speaking to Ms. Coster about, but I think hopefully that by March 11th date, we should be able to proceed forward. Remember saying that to the court?
Do I remember saying that to the court? No. If
Does reading that refresh your memory that you said it to the court?
I didn't read that portion, on what page are we on?
Yes.
You can read from here over to here.
Okay.
To yourself, please.
Sure. Yes, that's correct.
Does that refresh your memory? Maybe a rally that you indicated to the court that
This is bananas.
exactly right. There may be a couple of outstanding pieces that I'll check on, and some other pieces that I was speaking to Ms. Coster about, but hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said, yes.
Okay. And you know at that point that there were still 6 outstanding search warrants that you didn't have?
No, again, if I had known, then I would have gotten them and provided them.
It's crazy.
Okay. But weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the
But
warrants
where
themselves.
are the ones
So we're
from,
talking about search warrants.
Separate search warrants, yes.
where are the ones from
And nothing's ringing the
2021?
bell that you didn't turn over 6 search warrants?
Apparently not.
Okay. So the 2022 search warrants that we talked about in court back on January 24th of 2024. At that point,
It shouldn't be parsed. Did the search warrants get turned over? Yes or no?
Mr. King was indicted. Is
Not all
that
of
right?
them.
Yes.
Was Ms. Gardner indicted?
Yes.
All right. So what process did you go through to issue the 2022 search warrants after indictment?
Through this court.
I'm sorry?
Through this court.
So you went to Superior Court and asked for these search warrants. Is that right?
Myself personally, no.
Well, did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know
What
whether or not there's an
did you
obligation
do?
on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were,
Question, do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal.
What?
Yeah.
Sustained.
Thank you.
I'm kind of confused as to what she's asking.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
yes.
Okay.
He had forgotten by then, it seems.
And then we come back, we suggest March and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date, so there may be a couple of other additional items of discovery that I need to get and turn over. But otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
I don't.
Finish, Your Honor.
Just put the transcript in. Just put the transcript in as evidence. Just
These transcripts in the
Just mark
FTR,
it.
what's on the FTR, what was said by whom, when is all a matter of public record, and we can look at the FTR and get it. So specific quotes and what was said, what
Just
was represented,
Put it in.
that's part of the record, and we can see
But I
that.
just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Just ask
Thank
it.
you. So
The judge is
after
giving you
having made
leeway.
that representation to the court, did you do anything to get the 6 search warrants?
It
No.
seems he had forgotten by this
What were the
point that they
outstanding
even
matters as
exist.
far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
Apparently not.
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay.
Oh
Now,
my God.
other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay. But you understand, normally we file a pretrial conference report where you agree to give me what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference
I
report
mean,
I
that's
signed.
fair.
Okay.
He would need the file in front of him, but get the file.
And then we talked about the meeting with the state police. Did you have any meetings with the Milton Police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton Police the same type of discovery request that you would have sent to the state police?
This is wild.
Yes.
And did you follow up with the Milton Police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what, in your mind, was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
She just said it.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton Police turned over to you, would you have kept notes of that somewhere?
Yes.
Would there have been emails
Where?
back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked for things, did they return your email and give you what you were looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay. And do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through their file?
No.
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their file?
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the file?
At what point in the case?
At any point.
When they're done with their part.
Typically, that would be something that I would endeavor to do closer to trial.
Why?
Closer to trial.
Yes.
So how could you make
It's too
sure your
fucking-
obligation was satisfied if you're not meeting with the police until right before trial?
Right.
An ongoing duty and obligation that extends even beyond a trial.
That's fucking it. Somebody rewrite Rule 14 then. Rewrite Rule 14. It is an ongoing discovery obligation for shit that's new. Ongoing discovery obligation doesn't mean that old shit can just get turned over whenever. It's ongoing, meaning that if you've turned over discovery and then new stuff happens, you turn over the new stuff. Ongoing doesn't mean I do it when the fuck I feel like it. You turn over what you have. And it doesn't stop there. You're obligated to turn over anything that gets created after that point. Ongoing doesn't mean you just turn it over whenever you feel like it. That's not what the rule says. And that's not what the intention of the rule is. And just being like, I mean, it's ongoing, so I can turn it over whenever, is not true. The courts need to stop letting them put in evidence that they don't turn over. You didn't turn it over, you can't put it in. Well, Your Honor, I just got it. I don't give a fuck. The police department had it for how long? Great, you can't turn it over. Means you're going to have some real uncomfortable results on cases. And you're going to have some victims that are really let down. But ongoing doesn't mean I can just do it whenever. That's not what that means. Well, it's an ongoing obligation. I'll just do it whenever. You can't go to the department the week before trial and just be like, do you have anything else? I was so baffled when video was just showing up during the Karen Reed case. This is how that happens. Oh, I just didn't ask. You just didn't ask. And it seems law enforcement's just like, I mean, nobody ever asked me for it. Why would I turn it over? I mean, you didn't ask. Oh my God. Stop letting this evidence in. Stop letting it in. The behavioral change. It's just so crazy. And I can't imagine that this is just this one attorney. Because if everybody in the office is like this, then here we are. Well, I just do it before trial. That's not acceptable. I can't imagine that Norfolk County has more cases than LA County does. And if it does, then you need more DAs. But you're not going to get any more DAs. You know why? Because they spent $500,000 on Brennan and $400,000 plus dollars on Aperture. And if DAs are getting paid generously $100,000 a year, maybe, hire a new DA for 5 years. If you have that, if there was so much work that you can't meet discovery obligations that are constitutionally mandated and statutorily mandated and ethically mandated, then your office is understaffed. Oh, it's fine. This is fine. This is fine. And a number of you have asked, could Lally lose his job for this? No. No, he has civil service protection. No. He probably won't get reassigned. Are there any DAs in this office that are just, how is, this is not okay. This is not what's happening in other offices around the country. It's not. So if anyone's sitting there going, oh, this is how everybody, it's not. This is not how everybody does it. This is not. This is wild. And also, don't dump that shit on your colleagues. And just be like, so it becomes somebody else's fucking problem. It's just, Julia said, so basically no consequences. The court, there needs to be court consequences. And it sucks to watch a case get dismissed because of DA bad action. It sucks for the victims' families. This is a homicide case. But if the defendant's rights aren't protected and the attorneys aren't doing their job, the result is that cases get dismissed. And that absolutely sucks because the cost comes to the victims and the community. But those are what the consequences are. And there doesn't seem to be a ramping up of consequences. And this doesn't seem to be this one thing fell through the cracks. This seems to be I wouldn't even do that till trial. This seems to be the norm. Absolutely fucking bananas. If we had an officer that habitually wasn't turning over search warrants at some point, and I had a fuck ton of bosses, at some point, my bosses would have called in the chief of police and fucking screamed at them in the office with a door open and said, we're going to start your cases. Like, what are we doing? Why is everybody just so calm? That's fine. This isn't fine. This isn't fine. This isn't fine. This isn't proper. This isn't appropriate. If everybody is just, this is how it works, it's never going to change. This is why there have to be cameras in courtrooms, because how do you know if the DA in your county is doing a good job if you don't see shit like this? We should want people who commit heinous crimes to be punished appropriately. And we should want society to be protected. But the constitutional guarantees have to be protected. Otherwise, you end up with all kinds of horrific outcomes. When the rules are followed, people who did the thing have consequences. When the rules aren't followed, you have no idea what the fuck is happening. You can't. The rules are supposed to prevent this type of fuckery, but not if nobody enforces them. And that is on the judges. A community should feel confident that people's constitutional protections are being guaranteed. And that cases are going to go forward in a proper way, and that that their money is not going to be spent with cases getting convicted and then going up on appeal forever. Doesn't anybody care? Also, Norfolk County, you've got an election coming up in 2026. Go vote. Go vote. Go vote for somebody who's going to clean house, because it's going to take some big changes. And go vote. Go vote. Go vote.
Right, that's not my point. My point is, if you're not meeting with them and you're not going through their information,
It's wild to me.
how do you know you've turned everything over to the defense?
Because
Right.
I've requested it, and I've been given assurances or information indicating that that is what they have.
Let me
Vibes.
ask you the same question about the state police. Did you ever go through the state police file while you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
No.
Okay.
The court's like, did you ever sit down and go through the file yourself? No. I asked for it. I figured they'd give it to me. I do more follow-up on like a refund when I cancel a flight than they've done on this case. Like for real, for real. I asked for it. They'll turn it over. Obviously, they won't.
And can you tell us, was there a policy within the Norfolk County District Attorney's Office of sitting down with police
There's not
departments,
gonna be a
whether it's
policy
state
on
police
that.
or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend, case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and
A
ensure
few
that I
months ahead
have
of trial
everything
is
that
too
you have.
late.
Okay. And
It's
is there
too late.
is there any prohibition to that?
Look, I get it if we're talking about, I don't know, misdemeanor cases. Most things aren't going to go to trial. Most things aren't going to have this problem. But when you get to homicide cases, you can't wait until just a few months before trial. Are they just assuming that, well, it's going to plea, it's going to be fine? Because the defense attorneys need the warrants to run the motions, because they're not going to plea a case if they haven't seen all the discovery. Because if there's a chance they can get all the warrants yeeted, then they've got a much better case. This is wild. They're just like, we'll do it a few months before trial. Nothing's going to trial. It's going to be exhausting for the defense attorneys. But at some point, they're going to be like, we're taking everything to trial. We're not pleading shit. Good luck getting everything done. We're not going to plea anything. You're not giving us discovery. How do you let a client plea unless your client comes to you and is like, I totally fucking did this. Can you just get me the least amount of prison possible? And I want to go to that prison. I've been there. I like it. Like, you've got to see the discovery. This is crazy. We'll just wait till the end.
Meeting that you have a couple of months prior to trial happening right after indictment.
And it's the victims who
No,
pay.
and that would be
It's
my practice now. So you're asking about sort of my general
Oh,
practice.
you've changed your practice. The defendants also pay because they wait and wait and wait and wait. But so do the victims. You've got a homicide case here. I think it's one victim. It could be more, but you've got a homicide case here with a victim's family that's been waiting since 2021 for something to happen. That's awful for them. And there's no reason for it. I'm backing up. And then he says, my practice now. So it sounds like he's changed his practice.
Where I'm actually like, let me see the file and ensure that I have everything that you have.
Okay. And is there a reason, is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time. That would have been it at the time, but now I would do that much, much earlier in a case.
Oh,
Okay.
now.
And the state police the same way? Did you sit down with them at some point and look through their file, or you never looked through their file?
Now I would
No,
do
as
this earlier.
His Honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or at any point did they send you, here's everything that we have?
So for 20 years, it's like
My
fine.
request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything
Is
they
it
have,
asked?
that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in the case.
Yeah.
Okay. So when you go,
Y'all
in this
didn't
case,
get yelled at enough. Did y'all not get yelled at as you were new DAs? Y'all didn't get yelled at enough. Like, did you not have a calendar deputy that was just like, why the fuck is this case taking so long? Like, where is the supervision of senior DAs being like, what the fuck are you doing? Why has this not been turned over? Or is just everybody doing this? Everybody's just like, yeah, it takes as long as it takes. It's fine. Where are the senior attorneys saying, get your shit together, you're embarrassing our office? I continue to be floored that the minimum floor is not being met. I'm at code buffering. I don't even, Lally doesn't even get a code. Like, it's so bad. It's just,
you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial on September 8th. When were you planning on sitting down?
Well, he wasn't. He turned over the
Milton
file.
Police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
Oh, and then you didn't discover that there were things still missing?
By the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton Police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay. So when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, it's on my list of things to do, but I never get down there, you should get down and take a look at the files?
Not that specific, but yes.
What did you tell her?
That, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
Okay. So I'm still trying to understand, is there like when the police give you something, do they just email it to you, or is there?
I actually like the code Adam Lally and just let the lights cycle. That I can do. I can't even it's just so bad. Like this. There is no reason for defense attorneys to waste their time fighting to try to get basic, required, mandatory discovery for 5 years. They're not fighting over something that is maybe something that's not going to get turned over, or maybe something that it needs to go through the court. This is base level discovery. And it's not right. And if that means you go into a trooper's office and yell at them, then you go into a trooper's office and yell at them. I mean, what? They're not going to like you? Who gives a fuck? Have friends that you don't work with. Like, I don't understand how it gets this far without it being a problem. It's a problem for the defense, but it should be a problem for the court. And on homicide cases, they go to trial more than they plea. So at a minimum on homicide cases, turn everything over. We're just going to resume. This is
like a list
terrible.
To say, we gave ADA Lally these documents on this date.
As far as their list?
Yes.
I have no idea what they have.
Okay. So you don't know, as you sit here today, if they have
because you never checked. You don't know what they have.
all the things they say
exactly
they gave
right.
to you.
You have no idea what the cops have because you never asked.
And do you, on the opposite side, have an index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point, do you print out all your requests and say, okay, let me just make sure I have everything here. I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point?
Do you not
to make sure
index your
everything you
cases
requested
in a murder book?
My general practice would be, yes, and that would be as I know we're getting closer to a trial date.
So you wait.
Attorney Scapiccio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing.
So you're on.
Okay. Attorney Lally, you can step down. Thank you. For the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21.
So we're not even
CR
halfway
320.
done with
That's
this.
what we were going to mark as Exhibit 1. It's signed by you, Ms. Capiccio.
It was on behalf of Ms. Gardner.
I don't know, I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case, all right? Next dates.
Next dates.
I would like to have the benefit of your comparison of the old and new, the earlier disclosed and the later disclosed, and how the various items are different.
So,
Might I ask also that the court order if they're materially prejudicial to the defendant?
The judge might be
As we
appalled,
explore
but he is in work
Yeah,
mode.
I'm not sure where your microphone is, but if you can, your mic, can you speak right into the mic?
May
So-
I also ask the court to order what is materially prejudiced that
Right.
these materials? from
Right.
us?
It would be helpful to me if you're proceeding on a prejudice argument to know what it is that you contend is prejudicially late disclosed, okay? And,
might take a little longer, Judge, because last Thursday, we got some additional discovery from the Commonwealth.
well, let's start in tranches, okay? We can deal with April, and then we can deal with May.
Okay.
And if we have to deal with it in parts, we can deal with it in parts.
So you're on.
But I don't know how much time it's going to take for the parties to get together on this, and I don't know how far out we should look at a date.
And as far as the time frame for the material, how about when counsel filed the motion? Up until that point? I'm not going to,
Mr. McGee is
documents that were
suggesting, Mr. McGee is suggesting that which of the documents produced
Isn't the motion
as
pending?
of the time you filed the motion for sanctions or to dismiss,
Okay.
Yes,
do
the
you
motion is
now
pending.
view as prejudicial? That is to say, and frankly, how you were prejudiced, okay? This is a witness who's deceased, or we have no way of following up on this, or whatever it is, okay?
That's only part of the other, I don't want to not meet before that.
He's not saying don't meet before then. Oh, the DA was.
I mean,
I would like you to do a week, spend a week to try to get back and forth together on these.
Sure.
There's a long list, but it's not voluminous. You can deal with it. You've been through these documents. Each side has been through the documents.
Sure.
So hopefully you can come up with a list. And I'm happy to give you a date when we can continue this hearing.
so you're on. How far out do you think we need to go?
Well, it depends on when you can get that list together. I don't know how long it's going to take for you folks to get together, but we could do later this week for continuation of the evidence. We could do the following week, I believe, on the 29th to 30th in the morning. I'm not 100% sure.
could I bring the other parties in? I think each,
Sure.
another ADA is drafting
Sure.
parties.
So they're going to pick a day.
And I know we have counsel here
Date.
for another party, so.
If somebody has the transcripts of all the various hearings,
I do, Judge. I'm happy to share them with everybody.
yeah, share them with everybody and
The
let's.
defense is like, yeah,
Literally
here's
late last night.
here's everything y'all
But
fucking
my
said.
point is, in the next hearing, stand up and say, Exhibit A is all the transcripts of the various hearings on discovery. That's Exhibit 1. Okay. And Exhibit 2 is our reconciliation between the documents. And this is the way in which they're different or new. Okay. And Exhibit 3 is whatever else you want. Here's our discovery report. And here's my discovery motion. And here's the motion. You don't need a witness for that. These are all part of the record. And so there's going to be no contest as to any of that. That's just putting in the record. And then if you have specific questions for somebody, ask it. But so I think this can be done in a much more streamlined way.
It should have been done
and
4
hopefully
years
we can
ago.
do it that way. How much more, what other witnesses do you anticipate?
I anticipate Trooper Proctor, who didn't join us today, and I anticipate ADA Hickman. Those are the only three that I've subpoenaed, but based on the testimony, I think we're probably going to need Lieutenant Collins as well, Judge, and maybe Trooper Tully.
Yeah, I would just subpoena Tully now. Tell me more about Proctor not showing up.
All right, and how many witnesses do you think you're going to need?
Trooper Tully here, Deputy Chief Collins and Officer Benda, regarding the Milton issues. There was a motion to quash, and I know Your Honor's up against somewhat of a time with respect to ADA Hickman, being the predecessor counsel and now counsel of record on the case, that she can answer any questions the court can has that are remaining from right where she stands.
All right.
and opposing the production of.
All right, so we have 4, maybe 5 witnesses left. So we need a day when we can do this in an efficient way.
You need a full day.
Jim, how does our calendar look?
Well, 7/29, which is a Tuesday, is
Yep.
particularly good.
Particularly good.
Well,
There was
on that day.
There was a reason for that. I'm trying to remember
The judge
what
is
that
like,
reason
do
was.
I have plans?
We have a noon lobby conference.
There's a lobby
I
card.
have a federal case on, so.
29th is not going to work for you, okay?
How about the 30th in the morning?
You need a full day
We
for
have
5
anything on
witnesses.
that morning?
We do not.
No?
How do you have an open day a week out? How is that even possible?
First week of August.
Me, I'm just speaking in LA because a lot of the judges in LA are booked out 3-4 months in advance. The fact that there's an open day in like a week is wild to me.
The 30th is a problem for you?
I can have on the 5th.
Emily, how much of law is just trying to find a date where
6th
people can
is
be in the
out.
same
5th is
room?
a possibility, but I don't know
Yes.
what we have that morning.
All.
Okay, how about,
According to me, the 5th isn't good.
Emily, how much is picking dates? All of it. All of it's picking dates.
That's blocked
Mouse
up.
is about to die.
Let's just pull up the list for the 5th.
I'm leaving this open because this is half of the practice of law, it feels like, is trying to find a date everybody's available. I've got to charge my...
Hector Calderon, the lobby.
All right, so it looks like we could do August 5th.
just could, I know that,
Can you do that?
I can.
All right.
Does it work for
Witness issues, August 5th? That's okay? All right.
the judge could, I know that, Trooper Proctor's attorney is here. We did serve him in hand today. Could he communicate the new date, so we don't have to reserve him? I don't want to go back to his home.
Morning, Your Honor. Dan Moynihan
Fair
on
enough.
behalf of Michael Proctor. He can be available August 5th.
Okay, good.
I mean, he
So,
shouldn't be that busy. He doesn't have a job. He might have other hearings.
9 o'clock?
Sure.
I would like to get
Wow.
the agreed to exhibits, including the transcripts of any prior hearings, any prior filings that you want to draw to my attention, the reconciliation of exhibits, et cetera, in advance. So I am away the 31st and 1st. So if I have them here by first thing on the morning of the 4th, I'll read them all before the 5th, okay? So I'm not trying to create artificial deadlines for you, but I think everything will go faster if I've had a chance to take a look at the agreed to exhibits, okay?
Yeah, it would.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
9 a.m.
We'll take a 15-minute break and reconvene 11:30 on the motions to suppress.
Thank you, Your Honor. Thank you.
Grab the search warrant. Jimmy, do we have Zoom going? Sorry. Do we have Zoom going? Yeah, thank you.
Law nerds. I don't really know how this is happening. I mean, obviously apathy, but I'm not surprised the defense attorneys are losing their minds over discovery, probably all the time. And a lot of you have mentioned that some of the defense attorneys, the public defenders, have gone on strike, causing quite a lot of cases to be dismissed. I will take a look before the next hearing on this because it's wild. And the result is, at the end of the day, if people aren't doing their jobs, if discovery isn't being turned over, one of the discovery sanctions is that cases get thrown out, like we saw in the Baldwin case. But I will keep an eye on what is happening with this discovery just because it's involving the same parties. We cannot spend all of our time in Massachusetts as much as I would like to. But it's wild. So I'm curious to see where the end result of this is. I very much want to see Trooper Proctor have to testify about why he didn't turn stuff over. It seems that everyone is just like, yeah, sure, it's fine. It's just fine. I mean, there are other cases we are covering, but this is going to impact more than just this case, more than just Karen Reed's case. And at the end of the day, it is both the defendants who are waiting in custody too long for their cases to go to trial that are being impacted, but it's also the victim families and the victims that are being impacted. We saw the toll it took on the families yesterday in the Kohberger case, waiting to see if a case was going to go to trial, being frustrated that cases kept getting delayed and trial dates kept getting pushed back. You saw how much it impacted them and their anxiety and their stress and their frustration and keeping this going. I don't know how this is just the norm, but it seems like it is the norm. Because ADA Lally is sitting up there going, yeah, I ask and then they get it to me and then I ask again and then I ask again and then I ask again. But it seems that there's no consequences. And the consequences would generally come from the judge on a given case. Fine, you didn't turn it over, you can't use it at trial. Or you didn't turn it over, it's a Brady violation, report yourself to the bar, and your officer's on the Brady list, and the case gets dismissed. Or, what, the trial gets continued? Defendants don't want their trials continued. They want to go to trial, to know what the end result is. They don't want, and the court's like, well, you can just turn it over before trial, and if you need more time, we'll just give you more time. That's not a reasonable solution for a lot of defendants. And the DA's office isn't going to change if the result is they just get more time because they didn't do their jobs in the first place. Oh, you didn't get that done by the deadline? Okay, you can have more time. How many of you is that acceptable in your job? Oh, you missed a deadline. Oh, that's fine. We'll just give you more time. No big deal. Is that acceptable in any of your jobs? I've seen people flip out on baristas because their drink isn't ready in like 37 seconds. I mean, your average barista pick a coffee shop is going to have more stress in their life than Adam Lally seems to have. Federal judges will just throw your shit out, sanction you, and then talk shit about you in the comment or in the footnotes and just be like, this can't be the way systems work. It cannot be okay. And it ultimately, the office culture seems to be an issue. But if the judges don't enforce the rules, then there's no consequence for the DA. It's like, oh, I get more time. This one goes to the back end of the line. We'll take the next case that's rolling along. Because Attorney Lally doesn't seem to care. He's just like, yeah, I forgot. What's the big deal? Well, the big deal is your case can get kicked out. That's the big deal. And then you have a victim's family who is sitting there going, how? How did the people who did this not get held accountable? Oh, well, we didn't turn over the search warrants. Go sit down with the victim's family and say, I forgot to turn over discovery. Really? It's absolutely wild. And it's not how offices should run. Being a prosecutor is a job that you choose. And there are a lot of obligations that come with those jobs. And if you don't want those obligations, pick a different job. That's fine. Pick another job. But if you're going to pick that job, do the job. it's just absolutely wild to me that it seems to just be like, yeah, this is just what happens. I will take more of a look at this, y'all, and keep it on the docket and keep an eye, because it absolutely shouldn't be happening. And it is going to impact other cases. When I looked at the Birchmore case initially, and you guys are like, look at the Birchmore case, look at the Birchmore case, look at the Birchmore case. And I started looking at it, I went, holy fucking shit. What is happening? And then it's the Reed case. It's like, how is this going to trial? And now we're looking at this case going, what the heck? And we haven't even really talked about the Walsh case. This is not what we should be seeing in 2025 from prosecutors' offices. This isn't difficult. Sometimes the days are long. Yeah, for sure. It's a hard job. Yep, it's a heavy job. It's a weighty job. But making sure law enforcement turns over discovery shouldn't be the hardest part of your job. And if law enforcement isn't turning over discovery, then your office needs to rip someone to make sure that their office changes. It's really frustrating. And I can imagine that the defense bar in Massachusetts is like, do you all see now what we've been fucking dealing with? I mean, damn. Are y'all just bringing like Tums to court? Because I don't know how you're dealing with this. I'm sure the defense bar is like, yeah, we just bang our heads against the wall and say, but we don't have it, but we don't have it, but we don't have it. And the judges have the ability to step up. So you piss off the DA, who the fuck cares? You can't be worried about being liked. And if you were the DA, oftentimes you're not going to be. You knew that when you took the job. You've watched a movie. The DAs are often the bad guys. Especially if you're doing shit like this. You don't take a job as a DA to be liked. So you hurt Trooper Proctor's feelings? Okay. Do your job and your feelings won't be hurt. Like, just give me discovery and then we can all get along just fine. Sometimes you are going to piss people off by doing your job. And if that is not something that you can do, pick a different job. Like, lawyering is probably not for you also. If you are worried about hurting people's feelings and people not liking you when you are lawyering is maybe not for you. Because, yeah, people aren't going to like you doing your job. That's true. But if you are doing your job ethically and honorably, then you know that you're doing the right thing, and it doesn't matter if people don't like you because you're doing the right thing. Again, judges need to push these cases forward. And if departments can't turn over a search warrant that's already done, then we've got much, much bigger problems. I am just relatively pissed off and flabbergasted. Because again, when people are like, we can't trust prosecutors. Not when they're doing shit like this. That's not trustworthy. Well, I asked them for it. They said they would get it. Obviously, the cops that you're working with don't respect you because they're not giving you the shit that you need to get. Why not? Why aren't they giving you the search warrants? The defense attorneys should be able to run the motions to suppress in the first, 6 months of a job? Or the first 6 months of a case? You want your dockets to run more smoothly, judges? Let those early motions get run quicker because you've gotten the discovery turned over. It'll sort out what cases are going to trial and what ones aren't real quick. Those motions to suppress shouldn't be waiting till the end. The thing is that at the end of the day, if cases just start getting thrown out left and right, it is the victims who carry that burden. Because the office that is supposed to be seeking justice isn't doing their job. And I imagine the election in 2026 for DA is going to be a busy one. Because I don't think anyone watching these cases go down can be cool with this. Because we're not talking about, I don't know, a backlog of testing at the lab or something. We're talking about paperwork that is already done and relied on just not being given to the defense for no apparent reason. I'm real interested to see what Proctor and Tully have to say about it. I'm interested to see if this case actually gets to trial or if it gets dismissed. And I'm very interested to see where the motions for sanction goes. Because the defense is asking for motions for sanctions, it sounds like, for sanctions and for dismissal. Wow. I'm as frustrated as you are. I am absolutely as frustrated as you are. Some of you are asking, who is Lally's boss? Lally's boss is the elected district attorney at the end of the day. There's probably a few more in between there, but the elected DA at the end of the day. And I will take a look at the cases that have been dismissed with the defense attorneys being on strike between now and the next hearing. All right, I'm going to answer some questions and then I have got to scoot because I have got to jam. But I am going to keep an eye on this case. The Walsh case is on my list. I don't know when we'll get to it, but I'm going to keep an eye on it. We will get there. However, now that many have turned their attention to Norfolk County, it seems that we are going to start to see these cases getting coverage, having cameras in the courtroom, and being discussed. And that should start to change how things go. This isn't a teeny tiny district attorney's office. We have seen examples of district attorney's offices doing things really well. But that doesn't matter if you live in Norfolk County. It doesn't matter that in Utah, all the discovery just got turned over and now they're just trying to set dates for next hearings. That doesn't matter to you if you live in Norfolk County. It doesn't matter to you if you're Karen Reed or if you're a defendant whose attorney keeps coming to you going, yeah, I know you're still in custody, but the attorneys haven't gotten us what we need to go to trial. And I can't represent you without that information. And you need to have a fair trial. And they're not giving it to us. The court's not doing anything. So it doesn't matter if other offices are doing it well. Because when other offices aren't doing it well, it's a problem for the people who are A, paying everyone's salary, and B, hoping to see our legal system operate the way that it is intended to. This is not how it is intended to. Unless they've just baked inefficiency into the system in Norfolk going like, it'll be fine. And in that case, it is up to the judges to say that this is not how these cases are supposed to work. There is a human cost to this for the defendants and the victims and victims' families. I mean, if you were a victim of like an armed robbery and you are injured in that armed robbery and you are waiting for that to go to trial for 4 or 5 years, the amount of stress and anxiety waiting to have to testify in a case like that is going to upend people's lives. There is a cost to that. Do you not sit down and talk to the people that are your victims in cases? Don't do that job unless you want to help people. Because this is definitely not helping. And I am very frustrated. However, there's a lot of room for improvement here. And I'm really frustrated. I am optimistic that this isn't going to be let go, though. The shit's too far out of the horse on this for people to not continue holding this district attorney's office feet to the fire. As they should. Good DA's offices make their constituents feel heard. And like the outcomes are going to be just. We saw so many impact statements, and I don't know if I can start talking about impact statements without my entire throat closing up and starting to cry again. But we saw the impact statements in the Brooks case. And over and over and over again, we heard people talk about how supported they felt and how thankful they were for that support. Nobody wants to be a victim of crime. Nobody wants their loved one to be a victim of crime. No one wants to have to walk that journey in any way. But when people are, the offices need to support them. And they need to trust that they are going to be respected and treated with dignity. Because what happened to them is not anything that they ever expected would happen in their life. And as DAs, you are regularly just dealing with people who are having the worst. I mean, it's the same if you're dealing with social work. It's the same if you're dealing with, EMS and medical and others. You are regularly dealing with people going through the worst thing that they will ever go through. And they shouldn't have that linger forever and ever and ever and feel like it's like case number 182. Okay. And we see that in some cases where we see people be supported. And when we don't, we can call it out. Because this is not how cases should go. And the more we watch cases in different jurisdictions, though we were wildly busy in Los Angeles, the dedication and work I saw from my colleagues was 100-fold different than what we're seeing here. And we had DAs that came from other jurisdictions and worked at the LA DA's office. And we're like, no, you have no idea what it's like out there. And there were times I'm like, yeah, but it can't be that bad. I mean, I hear you, but like, it can't be that bad. No, girl, it's that bad. We're watching it unfold case after case after case, which is why there should be cameras in the courtroom. Because I'm regularly like, how are the judges letting this happen? And how are you not embarrassed? Like, it's just fine. I am optimistic that now that the bright spotlight has been turned towards Norfolk County, that it's not going to turn away. So it is so frustrating. We're going to answer some questions. And we are going to continue to take a look at this. We have other cases we need to look at, but we are going to continue to take a look at this as it moves forward. It might not be exactly on the same day, but we will try. I put August 5th on my calendar. We will see. But it is something our profession, especially within prosecutors, is going to have to deal with. Because it can't be that it's just, okay, well, we'll get to it when we get to it. It's an ongoing obligation. Whenever they get it to me, they get it to me. No, that's not how that works. And there should be consequences for that. And I think the only consequences that are going to get anyone's attention is when cases start getting thrown out. And I hate that that might be what it takes, because it is an incredible disservice to the victims and their families. An incredible disservice. But how does this just go on and on and on and on? I don't know. We need questions. We hadn't flown to Massachusetts, but I feel like we need to fly out of Massachusetts. Pick your favorite destination. That's where we're traveling, and we're going to have to do. We're gonna have to do some Q&A. All right. Let's continue on. In a totally non-law related question, where are my earrings from? The mods will put a link in. You can find the Kendra Scott earrings on Amazon. I have an Amazon link. It's actually an Amazon link that's an affiliate link. So then I can keep track of how many you guys buy. So we know. So they are an Amazon link there, which I appreciate. Chuckles Quad said cases like Kohberger and Brooks have set our benchmark, which only highlights the issues like these. And I appreciate that when we watch cases in all different areas, we get to see a wide variety of different offices and how they work. Nash Lee said Massachusetts just dismissed 120 cases because there's not enough defense attorneys. We're going to take a look at that next time. It's wild. Can Lally be ordered to review the whole case file before the hearing? He has to prepare for the hearing how he wants. The court didn't tell him to. I mean, he should have done it before anyway. Neuristic said, I feel like you were a unicorn prosecutor. I'm like, I don't think that's true, because there is a culture in that office of take this job seriously. Do your job. It is a hard job. And if you are not down for it being a hard job, get the fuck out. Do this job well. There was a push within the office of no, get it done, and support. If you're like, I'm having this problem with this police department, your supervisors would support you and be like, I will call their chief of police. I got you. So there was support, and there was a culture of everyone was getting their shit done. Is it always perfect? Absolutely not. It's a massive office with a ton of cases. So no. But the culture wasn't, oh, this is okay. So, but I only worked at a handful of the courthouses of the, 30 courthouses within LA County. It's a massive county. So the colleagues that I worked with, and I worked with a lot of people at a lot of different courthouses, wanted to do their job, and they wanted to do their job with excellence. And oftentimes, what I saw from people is they were frustrated when they didn't have enough time to do cases the way they wanted. And that was one of the most common things I saw, was DAs going, I want to have more time on this case. But that's not stuff just not getting turned over. So also, if you can't work up a case, they would get dismissed. Because if a case can't get done, it would get dismissed. It's not, oh, it'll be fine. We'll just go to trial without it. But again, I worked at a number of the offices, but we also had a whole training division. KCMH, am I going to DCI in Madison? I am going to DCI. I have no idea which one I'm going to. I'm getting on a plane. Is Madison in Wisconsin? I think so. Z said NBC 10 did a Norfolk survey. Only 4% support Morrissey. I'm not surprised by that after the Karen Reed case. It shouldn't happen. Prewa said the shit that was going on in the Karen Reed case now makes more sense. It wasn't an anomaly. It's a pattern. It seems to be a pattern. And I'm not surprised that Alan Jackson was losing his mind because he and I worked in the same legal culture of, what do you mean shit's just not getting turned over? That's not a thing that happens. So thank you for the gifted memberships. It's just not a thing that happens. And shouldn't be. But again, having a light shown on it is going to change things. And I imagine the judges will feel pressure in the ways that judges feel pressure, like people being like, how is this happening? Ew, what are you doing? It's wild. Absolutely wild. So let's see. Pharmacist Karaoke said, guess they should have used that $400,000 they spent on blue paint and hired some assistants and a management system. Tranquil said, this is so weird. Yes, it's like there are lots of jobs where you have to track everything. Like in civil law, this just shouldn't fly. But it just is bananas. Tranquil said, is he going to get blacklisted as a lawyer now? Because I can't see anybody wanting to hire him. Lally's got a job. Lally will have the job at the DA's office till he retires. Lally's got a job. So that's not going to change. Tredeman test person said, thanks to you, Rob and Ronco, I got my ADHD diagnosis 2 weeks ago at 35. You three showed me that ADHD is not what everyone thinks it is or said it is. Thanks. Yes, I think that, well, the more we discuss, the better things can get. And I remain optimistic in that. So the more we discuss, the better things can get. And yes, there are some, like, I don't want to say memes, but there are some standard, ADHD looks like this. And then if you don't fit into that pattern, it's like, oh, that's not me. It's like, no. It's a much bigger quilt of things. You need the whole iceberg. The iceberg might help, looking at the iceberg of what people think ADHD is versus all the other things. So it's wild. I also don't know the background or the facts of the case, but the apathy is wild. Yeah, it is. And wild. Wayne Brown said, does the DA's office own computers and use email? Of course they do. So the email records are available. Yes, if someone is emailing about it. But if they're like, oh, we just talked about it. Wild. Joe S. said, EDB, is it possible some or all of the warrants, of the missing warrants, do not exist? What are the failures that would have to happen for that to be the case? I mean, somebody would have had to yeet them because at some point they would have had to be presented to the court and the court would have signed them. And then there would be a return. But the court should also have a copy of them. The court that signed the warrants should have a copy of the warrants. So they shouldn't be gone. They should be somewhere. Let's see. Hey, Joe said, why are all these YouTube content creators all ADHD? That's fascinating to me. A lot of us are because A, we are hyperverbal. B, non-traditional work environments work for us. And C, we get hyperfixated on things, and normal jobs don't always allow you to get hyperfixated on a thing and then keep going. So I think you find neurospicy in different jobs where it works. Coding. I love tech. That was one of the directions I was like, where are we going? Because I could happily see myself working for 15 hours and then sleeping for 15 hours. So that non-traditional type jobs help very much. So you will see people kind of opting in to find the flexibility that works best for them. Same with music. I know a lot of music folks with ADHD that are just like, the music just makes my brain go purr. And so it works. And it's really finding where you can lean into the things that you love and that the confines of your job don't stifle that. And YouTube is one of those places where, well, it's whatever you want it to be. So you get to build it, because we can all do things differently and build things that work for us. And even all the different lawyers on YouTube have all different kinds of experience. Some are still seeing clients. Some are very active, still seeing clients. Some are still in trials. Some are not. Some have never done a trial. Some have done, like myself and the others in criminal, a fuck ton of trials. Some have done criminal and then into civil. It's just so much different. But I think with anything, you have to find a job that leans into the things that are more natural for you and do not make you feel like you are being like having the life just like leached out of you day in and day out. There are times where you have to do those jobs, but I loved lifeguarding. Lifeguarding was a great job. Like, you have a job, you have a task, and you have to perceive everything that's happening at once. What's better for an ADHD brain than having to perceive everything that's happening at once? It's fantastic. So it works. Let's see. So with ADHD or any other neurospiciness, it helps to outline the things you love to do and the things you hate to do and try to lean into a job with a lot of the first one and not as many of the second one. And then if you get to work for yourself, you hire people to help you with the second one. Quinta said over 120 criminal cases got dismissed in Massachusetts. Public defender refused to take one more case and won a raise since they only make $65 per hour. Morrissey sent millions maliciously prosecuting Karen Reed and found over $500,000 to pay Hank. I don't know Morrissey's not in charge of what the public defenders get paid. But if I were the public defenders, I would 100% be pissed, because it's the same county and the county pays the public defenders as well. Yeah, as they should be. In LA County, the DAs and public defenders are just all on the same pay scale. So it's just everybody's on the same pay scale. But yeah, if the office can find over $1 million to pay experts, they can find more. Kat in Virginia said, can we watch Trooper Proctor when he testifies? Yes, when former Trooper Proctor testifies, we can watch. I don't know if it will be same day or not same day. So this Boppet, I agree with you. Boppet says, daughter is a detective. I asked her about this. She turns over every requested document within 24 hours. She says she wants it off her list of things to do. Yeah. You don't want it to linger. If you just do it. Wasn't there a Friends episode where they were talking about paying credit card bills? And Monica was like, no, I get it and I pay it because I don't want to have to remember to do it later. Right. That works for me unless it's laundry. This is wild. So let's see. LB said, do prosecutors not get copied on search warrants from the beginning? They don't generally, but they have to use the evidence from the search warrant, so they have to get it. Emily asked, it's also because people think that these are one-offs. I've been yelled at for standing my ground on that this is more common than people want to admit. More people come to terms with it, the more Lallies get held responsible. It's true. And I'm not surprised the defense bar is putting their foot down. It's a reason systems have checks and balances. They have to have checks and balances. So, Aletha asked, can this defense lawyer get this client's case thrown out? That's what they're trying to do. That's what part of these hearings are for, is the motion to dismiss. So it is frustrating, but a lot of you guys have shared information with me and have questions. Chronic Shock asks, I'm quite behind, but Emily, have you ever been fined by a judge? No. I was threatened once, and it was because of my face. The judge was trying to make a point. My face was too loud in court. I did get yelled at by another judge for making a jury laugh because the judge said I'm the only one that gets to be funny. I had upstaged the judge by accident during jury selection because I had made the jury laugh. Unintentionally on my part. I was not intending to be funny. It was just a thing, and the judge got upstaged. And when the judge got upstaged, it was like, D.A. Baker, I am the only one allowed to make people laugh in this courtroom, and I am the only one allowed to be funny. If you do that again, you will get your checkbook. The judge was then trying to be funny and trying to be cheeky, but I was like, are you serious? I'm sorry. My bad. But yeah, there were times my face was loud. I would express my displeasure at times with rulings, but don't upstage the judge. Especially some of the judges are very theatrical. You've seen how lawyers can be theatrical. Some of the judges are very theatrical. So when you have a theatrical judge who is the center of attention, you do not upstage the judge. Sorry, Your Honor. One of my favorite defense attorneys that I worked with early on, I got reassigned to a case that he was on. He's like, I enjoy you, but I hate going to trial with you. And I'm like, I'm sorry, counsel. He's like, you're so likable and you're reasonable. He goes, it's so much easier with your colleagues that aren't as likable. I'm like, I know, because you're so likable. And when we're both likable, it makes it much easier for the jury to understand my case. When they think the DA's a dick, you win. I don't want to go to trial with you. I know. But we can get it all done together. Some things just need to go to trial. Gringa said, what procedural failures come up in a state audit? I have no idea if the state of Massachusetts would even audit their DA's office. The voters can vote out the DA. But it would often be the feds, but that's generally with law enforcement. And then you end up with like consent decrees and stuff like that. And that's a different time. Ashley said EDB's face is always loud. That's why she's on YouTube and not in court. Yes. Good commentator. I have no judicial demeanor. Emily, what's your judicial demeanor? Terrible. Terrible. Because a TV judge, yes. Reality judge, no. Because it's not judicially appropriate to sit there and be like, counsel, seriously though? Like, what the fuck? And I could never. Casey Cat said, enjoy the DCI show. I'm currently wearing my Cavaliers drum and bugle corps tank top, my new favorite. The Cavaliers are great. I told you guys I would show you a couple documents, and we're going to look at that real quick. But yes, we're going to look at that. I was definitely not the most likable DA. And I'm sure there were defense attorneys who did not like me. And there were just personalities that chafe. But I mean, you still work with people you don't like. That's part of being an adult. And then you get to pick your own job and are like, I just get to do what I want. Riley Bear, have you ever lost your temper in court? Oh, yes. I could be dramatic as well. I've told some of those stories, even the ones I'm not proud of, on members only. Oh, yes, I could be dramatic as well. I just didn't do it if I wasn't fucking right. I was not dramatic for just the sake of being dramatic. I was dramatic when it was necessary. Though I did have a colleague almost get held in contempt for throwing down over a protective order on a domestic violence case. And I was like, I got bail money. Do what you need to do. Do what you need to do. Let's see. I told you guys I would show you just a few of the documents, and then we will go from there. But let's continue on. I am going to pull up those, and then we're going to wrap because then I have to go back. I'm going to pull up those. We're not going to go through the doc. Look, as a quick caveat, because you are still here, I am going to take a look just as an example of the types of documents that we would expect to see. Because sometimes the visual helps. The Moscow Police Department is starting to put their documents, and Megalina, I'm going to give you the link, is starting to put their documents up on their website. If you do not regularly read police reports, or if you do not want to know the details of this case, I would give yourself a couple weeks and then decide if you want to go through them. If you want to go through them, go through them. I'm not going to tell you what to do. They are difficult, and I have skimmed only a few. But we are not going to go through those today. It is my intention down the road to summarize these for you and take out the way that I do when I summarize documents, take out some of the more difficult detail in a way that we can go through what we need to know, but not need to lean into the horrific. So I will at some point summarize them. So if you're like, I just want to wait, just tell me what I need to know. We can wait. For real. So let me grab those real quick because I thought I had, and then I had closed the tab as it happens. So I'm not going to, as I said, I'm not going to read any of these in. I'm going to show you what I'm talking about. Where did I put them? I have too many files. Let's see. So the first page, and this is not uncommon to what I have seen from reports. There are things that I thought were just standardized that are clearly not. You know, we learn something new every day. You go, how is that just not the way it's done? Like, it seems like it should just be the way it's done. So this is they're calling it the incident report. But what you'll see from this report is that it has the record number, the date, and what happened. So record number, date, what happened, subpoena sent. Great. Reports, great. Kohberger case, great. And then who's mentioned, who's involved, and a report number on every single thing. So they turned over all of the incident reports. And then from there, everything is connected back from what date, what report number, where it's from, and what the item number is. Report number, date, item number, King Road video, interview. Supplements, which is a supplemental report, T-Mobile DVD, blanket, curtain, shoes, Converse shoes, just Adidas shirt, item number 730. And you know what report they're all coming from. So when the defense goes through this, they just go through, that's the report number, that's the item number, that's the date. All of it. On and on and on. That's what you would expect. And they have a denotation of evidence. Evidence, report number, date, item number, and a description. Look at that. All pages and pages and pages and pages. This is 29 pages long. And then the initial narrative. The computer system would populate this if you put it in the computer. And they've all got numbers and then designations of what type of evidence they are. Their system would do that. You just connect it to her. Everything should be connected to a report number, which is why the issue was so big in the Baldwin case when it was under a different report number. Did you see in this example, and again, I'm using it as an example because we don't always have police reports in the cases that I cover. Everything has a number attached to it. But let me go to the top of the page real quick. But this is all tied to one report number or one incident number. If you were to put something under another incident number, it probably wouldn't populate on this form. And then the defense would not be able to go through the form and check it because if it's not tied to that incident number, it's not going to pull up here. And that's part of what was such a big deal in the Baldwin case, is that law enforcement put the information under a different case number. And there was no supplement case connecting them together, so there's no way to find it. It's all linked back. Sam said, so it's all connected back to the original. Yes. So there are supplemental report numbers. They're all tied to one incident number. In the Baldwin case, a huge part of the issue is that those were put under a completely different number. And I said at the time, okay, well, that makes sense, but you need a supplemental report number to tie them together so that people know they exist, because then that supplement will populate here and then it will be known. So I'm using the recent police report dump in the Kohberger case just to highlight some of the things we've been talking about in the other cases. The website has been very crashy, but I have all of these. So we will go through them. But the website has been very crashy. It's a lot of documents. So then even when you get to, I'm going to show you one more example, and we're not going to go through the narratives on these. But when I say, I mean, how do you not have this? And I seem baffled because it's really standard practice. You see that it's standard practice. I'm going to show you this other report, and then there's one more. I'm not going to go through the narrative. So if tomorrow's still a little bit raw, I'm not going to go through the narrative. But at the end of this, there's a recording of entry of when people were coming and going. At the end of the log. Who was where and when. During the entirety of both Reed trials, when I was losing my mind, and it was like, oh, we don't know how, I don't know who was on the scene and when. Oh, it's all written down. Remember when they just wrote it down on the evidence bag? Oh, it's just on the evidence bag. No, it's fucking not. This is what I'm expecting. Who's coming and going and when? Officer Morris relieved Officer Nunez. Great. At 1748. Then Officer Morris was relieved. Patio door was locked and sealed. Great. Warner arrived to relieve Officer Smith. Nunez arrived to relieve Officer Warner. What's happening and when? And who's trading out with who? It's all documented. All of it. It just takes people typing it into the system. This is just what they're doing in their system, and it's all tied back to the same incident number. Supplemental report. Who did it? What day they did it? The incident number, the sequence number, these are automatically populated once you log into the machine. What watch you're on, what happened, what you're doing. Was any evidence collected? No. Narrative. And then they go through the narrative. I thought that this was standard. I was really surprised to see that it wasn't. Because I don't even know what system you would use that wouldn't just do this. But I think that that's maybe the problem, is that things weren't getting put into whatever computer system Norfolk or Massachusetts state troopers were using. It just wasn't getting put in. That's what I think the problem was. This is going to hurt your brain. So let's just, for all of you that watch the Karen Reed trial, this is what I expected. This is a log of what the photos are. When the photos were taken, photo log. Photo 1, image file number, what it is. For every single photo. Every single photo. First floor bedroom east side, first floor bedroom east side, first floor bedroom east side, first floor to second floor stairs, second floor living room couch, second floor facing west towards west bedroom. Every single photo is listed. Every single one. Different cars that are photoed, what's photoed. And then the reason these IDs are taken out, they photoed everything there. These are identifying VIN numbers. What's the car? What's the VIN number? Not just Chevy. Not just clear plastic. Car, where parked. Car, where parked. Car, where parked. Every single car in the parking lot was photographed. Every single one. With their VIN numbers. So when the defense attorneys were buffering in the Karen Reed case going, who collected this? Who took this picture? And everybody's like, I don't know. This is what the attorneys were expecting. This is what they're expecting. How many photos is this? 182 photos. Every single one is outlined. So the defense attorney, if they know it's photo 132, they know it's the third floor southeast bedroom floor. These are the Moscow PD reports. These are not the FBI reports. And they uploaded the redacted reports. They uploaded over 300 reports. I am sure that you will see headlines coming out about them. Moscow said they're going to be putting up more reports. I don't know if I can remember a case off the top of my head where I've seen a police department say, have all the reports and take a look. This is what we did. But this is why they can. A, it's all organized. B, they were able to go through and redact everything. And C, they're like, no, you can look at the work that we did. There's no issue with transparency if the work was done. And I don't think requiring that level of transparency should be a problem. And when people start to kick about that level of transparency, I'm going to have a lot more questions. So I will look at these. If you do not want to read them, look, you cannot unknow what is in those reports. Reports are incredibly detailed. And it is okay to wait. In this case, I am going to go through them. I will let you know what we learn. I've had 20 years of experience going through not just reports, but cases like this. So if you want to wait for me to summarize it, it's fine. If you want to read them, it's fine. If you're not sure, just wait. They're not going anywhere. And if this website ever comes down, I'll just put them up on my own. They're not going anywhere. It's okay to give yourself some space. Yesterday was really, really hard. And it's fine. So you make that choice. I really appreciate that we're starting to see just the beginning. So I will be going through these. Madeline asked, do you have a plan for when we will go over them? I'm not going to start going over them this weekend because I also am going to take a step to the side from these reports for a minute. They're not going anywhere. The plea is done. We will go over them in due course. But I will 100% read them and summarize them for you. It just might take me a minute because they are, A, there's a lot of them, and B, I've got to get on a plane. And I'm not going to take them with me and read them while Griffin is sitting next to me on the plane. Because then I'll just sit on the plane and cry. Or be incredibly detached. And I don't want to do that either. So G has been giving me a hard time about, especially when we were in the retrial, working too much. So I am going to take a little time with G. Because the last trip for DCI, I was half work, half trip. I'm leaving the work at home this trip because G's just about to go back to school. So we are going to take a little family time where I am not bringing work with me. But then I will go through it. And then we will summarize it. But again, these details aren't going anywhere. Also, I'm sure most newsroom have like 4 people reading through all of these, and you are going to see headlines with graphic details coming out over the next few days. It is my goal to go through and highlight for you the evidence we did not know. That is my goal with the Kohberger case, and tell you how things got connected together, and then take some of the details that people are going to be leaning into and neutralize some of those and explain them in the way that I do. So if you guys see me out, I'll probably be wearing a Cavaliers shirt and my fax hat. If you see me out and about, just say, hey, I'm around. Law nerds, I will see you. I don't think I will be streaming Tuesday. It's just going to depend on flights. But I will be sharing photos from the travels, and I will be going and giving my kiddo a big old hug. Just a big old hug. And getting G ready for back to school. So I will see you next week. I will keep you posted in the chat. I suspect Wednesday. Travel shouldn't get crazy. That should be fine. So I suspect Wednesday. Law nerds, take care of yourself. Have a good weekend. Everyone give yourself a little bit of a step back. Yesterday was heavy and difficult. And it takes the body a little time to let the kind of emotions work through, because it is a really charged case. It's a heavy case. It's an important case. They all are. But it's also okay to let it move before we jump into the heavy. It's easier to be mad, right? The Lally fuckery, it's easier to be mad. The drop you to the floor grief is different. The mad is easier to tap into. But I am optimistic that where the attention goes, change can be made. And I'm going to remain optimistic. And we're going to keep an eye on it. Because you asked. Law nerds, take care. I will see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.